Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
Is the next search on February 28, 2020? 7:44 p.m. How, does the FBI find people? The people's misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Because he's the guy.
All right. I wish I could tell you. I wish I could tell you that I was busy getting some last minute things prepared for this live stream. I was just touching up a few, dotting the I's and crossing the T's. But no, to my shame, to my everlasting shame, I have to admit that I just did the last 10-minute live stream without hitting the live button. And I was responding to chats. I was welcoming people. I even did a roll call. And it's, you know how long it's been since we've done a roll call. I'm sorry. It wasn't until I saw somebody say, I guess Scott's late running on Rob time, that I realized that perhaps something was not all right in the YouTube land. That something was not as it should be. M. Young. I see that you're first in chat. That's what I see. Hopefully that is correct. M. Young, congratulations on being first in chat. You know that being first in chat has its privilege and punishment as well. We're going to punish you with ownership of the internet. You're responsible for taking care of everything IP-related worldwide. So when people start calling you, asking you how to change the clock on their microwave, or how to change the language that Alexa is suddenly talking in, or wondering why Siri is calling them a strange name, that will be all on your shoulders to fix. So just be prepared for that, and hopefully you can listen as well, because we have a doozy. We have a doozy to go over today. I am so sorry. Oh my goodness. Let's see. Whoa. I think we messed up. I think I welcomed Hippo over. I welcomed juror number one. I welcomed everybody. I did a roll call. I said, wonderful to have you all. It was amazing. But here we are. We're going to start. Now it's official. We're a little bit late. Let's see. I'm trying to see everybody I've missed everybody. I apologize, man. Okay, but here's what we've got. Okay, so just so you know, if you have not been following the Maya case, this is one of the biggest cases of this year and possibly of this decade, especially when it comes to the verdict and the impact this has, and it's just enormous. $261 million verdict, and ever since that verdict, the defense team has been filing motions that seem to be getting more and more outlandish with each day, and they go their claims are far out. They're from the deeper recesses of Reddit. They're so deep that I wouldn't be surprised if they have roots in 4chan. It's just absurd in some cases. They're huge stretches, in my opinion, to connect the dots, which aren't really there as far as I can see. But that's where we are, and we are now here live. Welcome everyone. We're going to do a little bit of a read through, because the document we have right here that just got posted. It was just filed today by the defense, by the plaintiff, from Greg Anderson and Nick Whitney, and it has their language all through it. It just you can smell their thoughts in here. It's so good. So we're going to do that. Is he still muted? What? What are you doing to me? Am I muted? I'm not. Pro streamer, we make mistakes. Please tell me this is working. Can somebody give me a thumbs up? Accidentally moved the comment. I think what happened is, M. Young, I think you were second in chat. I think Behemoth Monkey was first in chat. That's who I gave the internet to the first time. I'm not muted. It's working. Thumbs up. Okay, we're good. All right, Behemoth Monkey, all good. Let me just say, M. Young, can you train Behemoth Monkey really quickly, because you had the internet for a couple minutes. Just let him know what it was like, what you have to do, and what he can expect for the next, say, 20 hours or so until we go live. Well, it's not going to be that long. It's going to be about 12 hours until we go live. Congratulations, Behemoth Monkey. I think you truly were first in chat. I think it got accidentally deleted and that's my bad. It's all right. Good work. Okay. Let's start reading because we have a lot of pages. Oh my goodness, we have a lot of pages to go through. And by the way, Ro, thank you very much, gifting 5 memberships. We also just had a Atticus just became a new member. Well, again, this is month 2, I think, for that one. And we had one other comment right here from Kevin H. Another awesome month in the jury box. Thank you very much, Kevin. Kevin H. Bacon, great to have you here. Is this motion as spicy as we think it's going to be? Well, I think we're going to have to measure this in Scoville units. Okay, we'll measure it in Scoville units, and that means it might bring some heat. It may. Let's go ahead and dig in right now. Whenever you went to lunch, hopefully soon. It's a little spicy. So this comes from Mr. Greg Anderson, Nick Whitney, and the team et al. The first paragraph basically just says the defendants are Johns Hopkins, and the plaintiffs are the Kowalskis. That's what it is, and it's in response to the renewed motion to directed verdict, the motion for a new trial, and the motion for remittiture. Defendant's 144-page motion shows the defendant still does not get it. Defendant now blames the court and the jury and continues to maintain there was nothing wrong with the way it treated Maya and her family. The defendant argues in its motion that any injuries suffered by the family were not so bad and were the family's own fault, and any harm visited on Maya, Beata, Kyle, and Jack was caused by DCF because the defendant was simply following DCF orders. As the manifest weight of the evidence demonstrated, Johns Hopkins All Children's Hospital, through its doctors, employees, and agents, each of whom the defendant accepted a responsibility and liability for, did the following. Lat Cali Girl, thank you very much for the super chat. Thank you for reading this one. It's a long one. Buckle up. It's going to be good. So this is what the hospital did according to the plaintiff, and I've got some water I will drink periodically. Thank you on civil law. You're going to tear this apart from a legal standpoint. We're going to do it just for entertainment value as we have a little bit of laugh at what the attorneys managed, the elbows they managed to squeeze in here. So let's see what they have. Negligently and almost instantaneously changed Maya's complex regional pain syndrome, CRPS, diagnosis over the weekend of October 7th, 2016, although Maya's diagnosis had been confirmed by no less than 5 outside treating anesthesiologists, that's a big word, and neurologists, and recognized by the defendant hospital on each and every of Maya's approximately 20 previous visits and admissions to JHACH. Kept Maya in the hospital from October 7th to October 13th without legal authority and despite her parents' repeated requests for discharge. Refused to transfer Maya unless her parents signed off on the defendant's suggested diagnosis of Munchausen by proxy, and admitted that Beata had a psychiatric condition that led her to physically and emotionally abuse her daughter, only to hide behind its status as a pediatric hospital and claim that it had no ability to diagnose an adult like Beata. And covertly videotaped Maya to try to prove that she was participating in the charade to assist and cover for her mother, who had fabricated Maya's CRPS, and in doing so placed the commode out of reach so that Maya would be forced to get out of her hospital bed when she thought no one was watching. Instead, she defecated on herself and was dragged to the commode by hospital employees. Assigned Catherine Beatty, an employee with at least 3 documented disciplinary and anger management issues, to be the primary overseer of Maya. Allowed Beatty to repeatedly engage in unwanted contact with Maya, including hugging, kissing, patting Maya's legs, and placing Maya in her lap. Forced Maya to endure physical therapy without pain medications, and enticed Maya to push beyond her limits by enticing her with the promise of chocolate cake and going to church outside the hospital, only to be told by Betty that she had not tried hard enough and would not get chocolate cake or go to the outside church. Routinely interfered with Beata's visitation rights, allowing Betty to sit in, interrupt, and disparage Beata by making inappropriate faces, rolling her eyes, and otherwise acting like a toddler while Maya was on the phone with her mother. Required Maya to keep her hospital room door open while having what should have been private conversations with her attorneys, Michael Kelly and Mark Zimmerman, and rationalizing this infliction of emotional distress with the implausible excuse that the hospital staff had to keep the door open for fear of Maya falling and being left on the floor by her attorneys. Provided less than 5 hours of cognitive behavioral therapy over Maya's 3-month admission, even though CBT was, according to defendant and its experts, one of the pillars of the therapy for Maya's CRPS. Forbade Maya from engaging in religious practice despite the hospital's own patient bill of rights, and in the absence of any dependency court order authorizing such a prohibition, including removing Maya's religious artifacts from her room, instructing Maya's priest from her family's church that he could visit but not pray with Maya, and kicking out members of Maya's church who visited as part of the Legion of Mary with good faith intent to leave Maya with a statue of Mary to watch over and comfort Maya. habitually lied to Maya, as documented in the defendant's risk management file, telling her that her illness was all in her head. Her mother was in a mental institution, and Betty would be her mother now. Sought to drive a wedge between Jack and Beata by suggesting that Jack considered divorcing Beata. Forbade Maya from having contact and social interaction with other children on her floor, and further dehumanized Maya by not even placing her name on the door of her various hospital rooms. The vacation snark in this one is just lovely. Poor Shapiro. We're getting there, and oh my goodness, is it good. Ro, thank you very much for the 5 gifted memberships. Lauren Farmer, thank you as well. I love that you keep an eye out for me. Greeners as well. You guys did a great job hunting this document down and getting it to me so quickly. M. Young says, 3 months, I feel at least 3 years smarter since I joined. Thank you all. Let's see. I refused to give gifts that Beata and Jack brought to the hospital for Maya, including a birthday card to commemorate Maya's 11th birthday, and even a white Christmas dress, one of Maya's favorites, sent by Beata, both meant to remind Maya how much she was loved since she was forced to celebrate these occasions alone in the hospital. Refused FaceTime calls between Maya and Beata in the last 10 days of Beata's life, despite the dependency court's December 27th order that the hospital facilitate these FaceTime calls twice daily at 11 a.m. and 5 p.m. Stripped and photographed Maya over her objections and tears without her parents' consent, and under Betty's threat that if she did not allow the photos to be taken, she would not be allowed to attend the dependency court hearing later that morning. Conducted a relentless intimidation and harassment campaign against Beata, beginning with the refusal to honor Beata's request for Maya's discharge in the first week, with knowledge that the hospital's actions were driving Beata towards suicide and abhorrently predicting Beata's final act. Having now reminded the defendant of the outrageous conduct it refuses to address, none of which was compelled by DCF, plaintiff will respond directly to defendant's motion. To make this response more manageable, plaintiff will follow the format and organization used in the defendant's motions. Plaintiff does not, of course, agree there were errors, etc., as alleged in the defense headings, but to respond initially to some themes in those motions, plaintiff offers the following. As defendant acknowledged during the trial, this case is unlike any other. Thus, comparisons to other torts and verdicts in other cases, such as where a plaintiff died after a lifetime of choosing to smoke, are very limited value. Contrary to defendant's sky is falling claim that if this verdict stands, no facilities will agree to shelter children, the result here will mean that no facilities will treat a child and her family as the defendant treated the Kowalskis. Katrina, thank you very much. 4 months today. Appreciate you so much. The Florida Supreme Court long ago rejected the logic adopted by the defendant here, that JHACH should be given a blanket of protection by the Chapter 39 immunity provision, even though JHACH violated and abandoned its duty of care to Maya. More than 30 years ago, the Florida Supreme Court addressed this inverted logic in Department of Health and Rehab Services versus Yamuni. And in this, they're just reading the bold part, to so read Section 27 would turn Chapter 827 on its head by protecting the legal protector, HRS, from the protected class. Section 827 protects against liability for carrying out the protective measures of Chapter 827 on behalf of the protected class. It does not protect against failing to carry out the protective measures. It's a little bit convoluted. That's legal speak. We'll let Kurt tear that one apart a little bit tomorrow when he covers this. HRS is the predecessor of DCF, but the same logic holds true. Whether DCF, a sheltering institution, or a foster family, those who find themselves entrusted with the care of children via an intervention by DCF have a duty of care. A person taken into custody is owed a common law duty of care. To find that a custodian breached the duty of reasonable care, a plaintiff must show the injury to have been a reasonably foreseeable consequence of the custodian's negligence. Johns Hopkins All Children's Hospital is no different. Having been entrusted with Maya's care during her sheltering, the hospital owed her reasonable care. Defendant objectively failed to care for Maya, instead placing her in harm's way of its agent, Dr. Sally Smith, to provide the charade and Betty to carry out her perverted motives. Plaintiff repeatedly put defendant on notice of the harm being visited on them, as demonstrated by the risk management records and letter addressed to Dr. Jennifer Kazenstein, complaining of Betty's inappropriate conduct. Yet, despite the actual knowledge and foreseeability of this harm to plaintiff's family, defendant took no action. No child had ever been sheltered in defendant's hospital for as long as Maya, over 3 months, because Maya's situation was unprecedented. Defendant's dire prediction of the negative impact this verdict would have on other sheltering families is unwarranted. Upholding the jury's verdict, however, confirms that the sacred duty to care for children also extends to sheltering institutions, including children's hospitals. Chapter 39, Immunity. Drink. Happy Bath Bar. Welcome to the gallery. Thank you. Look at that green courthouse. Thank you so much. Chapter 39 immunity. The court carefully carved out the actions that were not subject to Chapter 39 immunity. As defendant notes, the plaintiff moved before trial to take Chapter 39 out of the jury's consideration, although by the court preventing any mention of out of the jury's consideration altogether, by the court preventing any mention of the DCF proceedings. Defendant successfully opposed that motion because it wanted the jury, not just the court, to know about Chapter 39 immunity. Defendant now regrets its strategic decision, claiming that Chapter 39 immunity was used as a sword and not a shield. Maggie Carr, thank you very much for the super chat. That's super generous. We appreciate you so much. Aside from being wrong, defendant got what it wanted and cannot now blame anyone but itself. Defendant should be glad the jury did not hear the full extent of its and its counsel's active role in prosecuting the DCF proceeding and urging the dependency court to implement the constraints and restrictions on the family's visitation rights that defendant attempted to hide behind during the trial. Negligent training. Defendant repeatedly asserts that negligent training claim should have been directed out sooner and is another source of its problems. As discussed below, Florida law requires hospitals to have competent staff. Proper training and supervision is part of that mandate. As it notes, plaintiff offered to make that a part of the medical malpractice claim, but the defendant refused. Without trying to assess blame, no agreement was reached. But this is all irrelevant, because defendant ultimately acknowledged that negligent training was relevant to the punitive damage claims. Mr. Altenburn says, there may be some element of this negligent training that relates to punitive damages claim, so I always kind of listened to this with the same interest that you had. Not that I'm not sure how it ties into punitive as compared to training, but I'm not going to tell you that I'm 100% convinced that there's not, as you've used the word, scintilla of evidence that this somehow relates to punitive damages. I'm essentially conceding to you that there's a level of this that can be talked about for punitive damages. So they use his own words against him. Defendant has not pointed to anywhere that it requested an instruction limiting the training evidence. Defendant's motion at page 130 acknowledges that keeping Catherine Beatty assigned to Maya's care was a negligent act of supervision or training, as discussed below. Hospitals are legally responsible for adequate training and supervision, whether the actor is inside or outside the scope of employment. Specific intent. The question of whether defendant had the specific intent to harm Maya Kowalski for purposes of punitive damages limitation of section 768.73 was properly on the verdict form for the second phase of the bifurcated proceeding per the standard jury instructions. It's a little complicated, but the way it was written on the jury instruction is right, according to the plaintiff. Putting the specific intent question on the verdict form in the first phase would have introduced an issue as to the amount of punitive damages before a jury finding that punitive damages were recoverable. Defendant also has shown no harm from this because it has not argued, nor could it, that the amount of punitive damages awarded exceeded the maximum amount awardable under the section. Defendant had the opportunity to present evidence on the specific intent issue in the second phase of the bifurcated proceeding. Despite the court's repeated admonitions that the punitive damages phase would follow directly and immediately after the jury returned its verdict, if it found in the plaintiff's favor, defendant apparently failed to prepare its evidence to rebut plaintiff's punitive damages evidence, and, as a result, failed to present its evidence at that time. The delay beyond November 9th defendant requested was not reasonable and apparently was dictated by the vacation plans of one defense team member for the week beginning November 13th, as discussed next. That's Shapiro. We're looking at you. Defendant argument was that it was harmed by the court's decision to place both options for the burden of proof on the specific intent issue of the verdict form. It's speculation at best, with the jury not needing to reach the lower standard alternative question. As was done with other items, the verdict was structured to avoid having to retry the case. Time. The defendant's insinuation that it was harmed because the court did not give it adequate time to present its case was never raised during trial, nor did defendant use all its allotted time or make a request for additional time that the court refused. The court did not make a definitive pronouncement that the trial could not continue into the week after November 9th. In fact, the court alerted the jury during the jury selection that the trial may extend into the week following November 9th. Also, it was defense counsel who expressed reservations about extending the trial due to the defense counsel's planned vacation for the week beginning November 13th. Ultimately, defendant rested its case in chief, having not exhausted its available time. This was the defendant's decision, and it's alone. Christiane, member for 2 months, says, yes, I finally got my green, but I have been here since JD versus AH. Thank you for all the work you put in. Thank you. I appreciate that, Christiane. Thank you. Damages including non-duplication instruction and allocation among torts. The amounts of compensatory damages awarded in this case were supported by the evidence. The jury is allowed wide latitude in setting non-economic damages. Defendant offered no methodology or evidentiary basis of its own for the jury to use to calculate compensatory damages and told jurors, use your common sense. The jury was instructed, although these claims are separate claims, it is possible that separate claims may result in overlapping damages. Your verdict should not award damages twice for the same loss, injury, or damage, even if they result from different claims. Your award of monetary damages for each claim, if any, must not duplicate the same damages awarded in the other claims. Defendant did not object to the plaintiff's closing suggesting that the jury allocate damages following from multiple acts by the same tortfeasor among the torts of the jury's discretion. Allocating among claims is consistent with the multiple events instruction when there were multiple tortfeasors. Okay, so here they're saying that the money the jury allocated, that they said, okay, for this charge, we're going to assign this much money, and this charge for this much money. There are instructions where they can't have one injury that gets paid twice, right? You don't pay the bill twice, and they can't overlap. They have to be separate. And the plaintiff's saying, hey, they followed the rules. Allocating, defendant did not object to the plaintiff's closing, suggesting the jury allocate damages following from multiple acts of the same tortfeasor among the torts in the jury's discretion. I read that part. Florida standard jury instruction. Plaintiff had proposed a much simpler verdict form that did not allocate damages among the defendant claims, which defendant rejected. With different claims, which the defendant rejected. Plaintiff presented, oh my goodness, let's try that one again. The plaintiff presented a logical option for the jury to evaluate damages for Maya's physical and all family members' emotional pain. The jury heard testimony that Maya's CRPS is the most painful neurological condition from which a person can suffer. A few numbers defendant did suggest at trial, unsupported by any evidence, were numbers for damage as a whole, such as future medical bills, not apportioned by the claim. So it is too late for the defendant now to argue for limits on specific items when it did not share those numbers with the jury. Contrary to defendant's conclusatory statement, as discussed below, the punitive damages bore a reasonable relation to the amount of compensatory damages, and none of the punitive damages exceeded the statutory cap set forth in Section 768. Defendant forgets one purpose of punitive damages is deterrence and does not argue the amount was unreasonable in light of the large amount of its assets. The jury paid rapt attention to both sides and was respectful to counsel, took copious notes, and asked thoughtful and penetrating questions of both sides. The court religiously reminded the jurors of their duties, and they consistently reaffirmed they were following them. This court observed that this jury did its job. Now, speaking of juries, juror number one, he's got a motion just for himself. Oh my goodness! But here we go. Buckle up, this gets good. A key theme of the motion is that the jury was under the leadership of juror number one, and the verdict, therefore, was tainted. This is pure conjecture. As discussed in the plaintiff's response to defense motion for a new trial based on purported conduct of juror number one, defendant has offered no facts whatsoever in his motion that showed that any juror acted under the leadership of other jurors. Moreover, a verdict is not subject to attack based on matters that inhere in the verdict, i.e. those that arise during the deliberation process. The verdict cannot be impeached by conduct that inheres in the verdict and relates to the jury's deliberations. Whether the other jurors viewed juror number one as a leader would just be such a matter. Affirming trial court's denial, the case law, affirming trial court's denial of juror interview regarding allegation that juror coerced other jurors into awarding more money because that was a matter that inhered the verdict. So basically, this is all part of it. Hey, juror number one, thanks for your super chat. RA, thanks for reading. Makes neither sense. Makes better sense coming from you. Wish I could convince Hippolover to read to me. Thank you, juror number one. Appreciate that. This juror number one is who we're talking about, by the way. Juror number one, welcome. We're talking about you. If I get anything wrong, please correct me. All right. So basically, they're saying that the juror number one didn't lead, and even if he did, this is something that happens in the jury. This is how they discuss. If somebody has a more persuasive argument and convinces people to follow them, that's not wrong. Let's see. Under Florida Standard Jury Instruction 700, the jury is directed to accept a leader in the form of a foreperson as its first act during deliberations. Jurors' ability to understand the case. Finally, another key theme of the defendant's motion is that this case was just too complicated for the jury to understand, and its verdict shows it was confused. The medical and scientific evidence was complex, a difficult, intentional tort for a jury to understand. This high-profile case presented to a national audience would be nearly impossible for most juries, even with a different foreperson. Even if, the average people from a bus stop, yeah. Defendant goes so far as to say that this case is easily 9 times more complex than the normal case. 9. They did the math. Respectfully, that is nonsense. Simply because the defendant was unable to persuade the jury it did nothing wrong does not mean the case was too complex to be understandable or that the jury was confused. Rather, the evidence and the verdict reasonably show that the jury astutely saw through the defense. Perhaps the result would have been different had the defendant shown even a modicum of contrition or acknowledged that could have handled the situation better. Juries routinely handle complex issues, including lengthy, complicated intellectual property, antitrust, conspiracy, and medical malpractice cases. The jurors' thoughtful questions throughout the trial in this case showed they closely followed and understood the evidence as it came in. And now we have a table of contents. Legal standards, directed verdict, new trial, amount of verdict, standard of review. We've got all the stuff in here. So we're going to skip down through the table of contents. Just know we have instructions of how to get to different places. And here we go. Plaintiff will not reiterate the case law of the standards recited in defendant's motion, but amplifies some areas. Directed verdict. In evaluating a directed verdict, and that is where the judge determines and says, I'm deciding that this is what the verdict is in this area, in this, this charge. In evaluating a directed verdict, the trial or appellate court construes all facts in evidence and every reasonable conclusion or inference based thereon in favor of the non-moving party. Katrina, thank you very much for gifting a membership that went to Minnesota Nice. Meaning that the court has to look at the facts and evidence in favor of the non-moving party. So if the defense made the motion, they look at what evidence is there in favor of the plaintiff. Does that make sense? A directed verdict cannot stand if the evidence is conflicting or different conclusions or inferences can be drawn from it. The court may not pass on witness credibility or weigh the evidence. Namely, all contrary evidence of explanations on which the defendant seeks to rely must be disregarded as rejected by the jury. Because the full transcript is not available, the plaintiff notes for preservation, a party waives the issue of legal sufficiency of the evidence by failing to move for a directed verdict on that issue at the time of the trial. A party must timely move for a directed verdict at trial to serve as an effective motion to set aside the verdict and to enter judgment in accordance with the motion for a directed verdict. Let's see. Florida law, as amended in 2010, eliminates the requirement for renewing at the close of evidence a motion already made at the close of the adverse party's evidence. In other words, the moving party must have moved for a directed verdict on the specific issue at the close of the adverse party's evidence or the close of all the evidence. This is preserving the issue for appeal, as well as this is just the process you have to follow to get the timely objections right. Good luck on them 88 pages, RA, says people for real. We're tearing through these. We're going to get there. A directed verdict is appropriate only when there is no evidence upon which the jury could rely in finding for the non-moving party. No evidence. This is key. Okay, so if something was charged against JHACH and there was zero evidence put in that it existed, then you would have a directed verdict in favor of the defendant. Let's see. Notably, a renewed motion for a directed verdict cannot be used to test the sufficiency of evidence to support a verdict. The trial judge is not warranted in withdrawing the case from the jury or in setting aside the jury determination on conflicting evidence or substituting, therefore, his own evaluation of the evidence. If the evidence is there, it goes to the jury. The judge is not the one that decides. He only decides if there is evidence or not. New trial. A trial court may order a new trial when the jury's verdict is against the manifest weight of the evidence. If you had all the evidence came in and said, this guy committed this murder, we've got video of it, he's confessed to it, all the neighbors watched him do it, we caught him in the act, he was arrested, he's been in custody since then, and the jury came back and said not guilty, the judge could say we need a new trial, right? If the jury's verdict is against all the manifest weight of the evidence. A motion for a new trial is directed to the sound, broad discretion of the trial judge who, because of this conduct with the trial and his observation of the behavior of those whose testimony the finding of fact must be based, is better positioned than any other one person to fully comprehend the process by which the ultimate decision of the triers of fact, the jurors, is reached. However, a trial judge is not free to behave as a super juror by disregarding a jury's verdict simply because the judge would have rendered a different one had it been the judge's choice to make. In deciding whether the evidence manifestly weighs against the verdict, the trial court must necessarily consider the credibility of the witness along with the weight of all the other evidence. The only credibility question the defendant raises in Maya's recollection of the photography session raises is the Maya's recollection of the photography session. And that's motion 6667. But there is no question clothing was removed and pictures were taken while defendant's staff held Maya down. Defendant does not contend to this issue. The credibility of witnesses is a key to the court's evaluation of its new trial motion. As the defendant's error discussion recognizes, the trial judge who oversaw the case firsthand is accorded deference. The court first determines whether there was an error, and if so, applies the harmless error standard. The court also reconsiders if the evidence was a feature of a long trial. The evidence of the car burning was not a feature in this example of this lengthy trial in which the over 40 witnesses took the stand. So that's just case law. The amount of verdict and remediator issues. Standard of review by the trial court. Florida statute states that after a jury awards damages, it shall be the responsibility of the court, upon proper motion, to review the amount of such award and determine if such amount is excessive or inadequate in light of the facts and circumstances which were presented to the trier of fact. The purpose of remediator is the additor is reflected in section 768. Quote, that it is the intention of the legislature that awards of damages be subject to close scrutiny by the courts and that all such awards be adequate and not excessive. In assessing whether an award is excessive or inadequate, the court shall consider the following criteria. Whether the amount awarded is indicative of prejudice, passion, or corruption on the part of the trier of fact. Whether it appears that the trier of fact ignored the evidence in reaching a verdict or misconceived the merits of the case relating to the amounts of damages recoverable. Whether the trier of fact took improper elements of damages into account or arrived at the amount of damages by speculation or conjecture. Whether the amount awarded bears a reasonable relation to the amount of damages proved and the jury suffered, and whether the amount awarded is supported by the evidence and such that it could be adduced in a logical manner by reasonable persons. Although the trial court must consider each of the foregoing statutory criteria, the weight given to each is discretionary. That case law noting that standard of review on a trial's court's order granting remediator to be clear showing of abuse of discretion. There has to be a clear showing of abuse. Overlapping these requirements, the court must also review a punitive damage award to ensure that the manifest weight of the evidence does not render the amount of punitive damages assessed out of all the reasonable proportion to the malice, outrage, and wantonness of the torturous conduct. The award bears some relationship to the defendant's ability to pay and does not result in economic castigation or bankruptcy to the defendant. It can't destroy the hospital. You can't say, we're going to take every last penny. A reasonable relationship exists between the compensatory and punitive amounts awarded. Punitive award must have a reasonable relationship to the amount of damages proved and the injuries suffered. A punitive damage award must further satisfy the federal constitutional requirement of due process by the court's measure, and the award according to 1, the degree of reprehensibility of the defendant's misconduct, 2, the disparity between the actual and potential harm suffered by the plaintiff and the punitive damage award, and 3, the difference between the punitive damages awarded by the jury and the civil penalties authorized or imposed in comparable cases. The Florida Supreme Court has noted that, in addition to the foregoing factors, amounts awarded in similar cases has least a limited value in determining whether an award is excessive. Let's see. Comparisons with other cases are sometimes fraught with danger because, of course, each case is different and must of necessity be measured in the light of the circumstances peculiar to it. In other cases, while verdicts in other cases may be instructive, those cases are not dispositive in determining whether a specific verdict is excessive. Here's a siren going off. And he gives some examples of this in the tobacco case, particularly. to see if the award was excessive. To characterize this as a unicorn case understates the horrific acts defendant committed in combination to inflict damage on the Kowalski family. Until defendant can bring forward a case where the jury found the defendant liable for battery, false imprisonment, medical malpractice, and intentional infliction of emotional distress, a comparison of verdicts in other cases is of limited value. They're saying you can't compare this. You can't compare this to other places. Let's see. Because apparently Reddit, of all places, is the new hot legal research app. Move over Westlaw and LexisNexis. I'm not sure if I made this joke when I was speaking to the air, or if I told you this one already, but I really think that the defense may have dived deep into Reddit so far that they were actually reaching down into 4chan to get some of these arguments. Great comment there, Shauna. Time for more water. Hang on. Defendant suggests that this case should be compared to smoking cases because of the size of the punitive damage award. But those cases where adult smokers voluntarily engaged in conduct once the dangers were well known are not remotely like what the defendant intentionally, as the jury found, what the defendant did intentionally, as the jury found, to this young girl and her family. Defendant cites 2 commercial cases addressing damages, renovations to a restaurant building, and the one where the plaintiff failed to establish what portion of the goods was received in bad condition. In citing 2 commercial cases as its primary case law for a mediator, the defendant overlooks, or perhaps tries to capitalize on, the fact that the courts have applied the certainty requirement for damages more stringently in contract cases than in tort. The reason for more stringent application in contract is that in tort, once defendant is in the area of risk created by defendant's wrong, defendant is usually liable for all the injuries caused by his misconduct. Even the primary case cited by the defendant for the premise that the trial court may order a new trial on the grounds that a verdict is excessive, Brown via Estate of Stuckey, was plagued with issues unrelated to a determination that the jury's award was excessive. The foreman visited a farm central to the commercial dispute, and jurors had ongoing conversations about the case during trial. And although the defendant cites Kane via government insurance for the premise that a new trial may be ordered on the basis of an excessive verdict when the record affirmatively shows that the jury was influenced by considerations outside the record, defendant offers nothing from the record to begin to argue that such outside considerations entered here. Michelle Marcus, welcome to the gallery. Thank you so much for your continued support. Love the Green Courthouse. Defendant frames the legal question this way. Whether the verdict is so inordinately large as obviously to exceed the maximum limit of a reasonable range within the jury as obviously to exceed the maximum limit of a reasonable range wherein the jury may properly operate. Defendant never gets around to demonstrating to the court what reasonable range the jury could have properly operated within, and cannot make such a showing from the record since defendant failed to put on any evidence suggesting an appropriate measure or range of damages. Likewise, the defendant cites no false imprisonment, battery, medical malpractice, or intentional infliction of emotional distress cases to demonstrate a reasonable range. Defendant also fails to mention that Bold also reiterated that a party who assails the amount of a verdict as being excessive has the burden of showing it is unsupported by the evidence, or that the jury was influenced by passion or prejudice. The Florida Supreme Court emphasized in bold that there is an element of speculation in most personal injury verdicts, but this is a matter for the jury's discretion. The court may review their discretion, but not the amount awarded unless shown to be clearly arbitrary. The determination of the amount of such damages is peculiarly within the province of the jury. In fact, defendant's arguments throughout the remainder of its motion demonstrate that the jury's verdict was consistent with the per diem decalculations plaintiff suggested, and though defendant complains of the methodology, only an award in the line of defendant's closing argument would have been arbitrary. Defendant's suggestions in closing were drawn from its hip pocket rather than from being based on record evidence. These are the numbers that they suggest, right? They're like, we're thinking maybe all in all, total, like what was it? What did they say, like 2 million? I forget what ridiculously small numbers. Queen Olive, wow, almost a year. One more month. You'll be orange. That'll look awesome. Thank you, Queen Olive. Okay, as discussed below, the plaintiff's evidence provided a basis for the jury's award. The expert testimony provided a range for the jury to exercise its discretion in awarding both the medical and the lost earning damages that would exceed the numbers blackboarded. That's the numbers that were offered there. Deference to juries continues under the statute. Notably, Florida law makes it clear that this statutory review of jury awards by the court is not intended to replace the discretionary authority historically given to juries, and that the legislature recognizes that reasonable actions of a jury are a fundamental precept of American jurisprudence, and that such actions should be disturbed or modified with caution and discretion. They're saying use a lot of caution when you're going up to second guess a jury. I love the hip pocket shade. It's got some good stuff in here. All right. Because of the inherent difficulty in measuring these kinds of non-economic damages, this court has determined that the jury, guided by its judgment and everyday life experiences, is in the best position to make fair assessment of these damages. Holding reasonable recompense for parental pain and suffering is largely speculative and difficult of determination. No one's estimate is better than a jury's. There is no exact standard for fixing the compensation. The extent to which a jury could have believed or disbelieved certain witnesses when coming to its verdict on damages is a factor the court can consider in deciding to give deference to an award. This deference to the judgment of juries has been recognized specifically regarding damages in wrongful death actions because who can place a dollar value on human life, measured by the loss of grief or a loved one? That difficult decision is generally one for the jury or fact finder, not the appellate court. Likewise, the wide latitude accorded juries in determining the amount of awardable damages has been especially true of punitive damage awards, which are peculiarly, I cannot say that word today, peculiarly, the P word, left to the discretion of the jury, as the degree of punishment to be inflicted must always be dependent on the circumstances of each case, as well as upon the demonstrated degree of malice, wantonness, oppression, or outrage found by the jury from the evidence. In Reddy, for example, the 3rd District reversed a trial court order remitting a punitive damages award, holding Reddy was entitled to an unprecedented compensatory and punitive damage award so as to fit the vicious arrogance of the defendant's conduct and the life-shattering damage inflicted intentionally with malice aforethought. Accordingly, a jury's wide-ranging authority to determine these damages has long been subject to limited trial court superintendence, though the post-trial order of remittiture or new trial. The underlying rationale for such limited superintendence is to prevent so-called haywire or runaway verdicts from standing. The trial court itself has limited discretion to interfere with a jury verdict and must give due deference to the jury's broad discretion to fix compensatory and punitive damages. Consequently, only when the manifest weight of the evidence dictates that a remittiture must be granted is such an order appropriate. In keeping with these precepts, the 2nd District articulated its concern about reducing jury damages awards in tort actions as follows. Where recovery is sought for a personal tort or where punitive damages are allowed, we cannot apply fixed rules to be given a set of facts and say that a verdict is for more than would be allowable under a correct computation. In tort cases, damages are to be measured by the jury's discretion. The court should never declare a verdict excessive merely because it was above the amount which the court itself considers the jury should have allowed. The verdict should not be disturbed unless there is so inordinately large as to obviously exceed the maximum limit of reasonable range within which the jury may properly operate. Limited authority is therefore accorded to the trial court to check the occasional haywire or runaway jury, without in turn giving the trial court a blank check to do so. Determination of an excess award must be based on the specific facts showing impropriety. The fact that damage award is large does not itself render it excessive, nor does it indicate that the jury was motivated by improper consideration of arriving at the award. Rather, a remittiture must be based on the findings of specific facts accounting to impropriety, as stated in Lasky v. Smith. The record must affirmatively show the impropriety of the verdict, or there must be independent determination by the trial judge that the jury was influenced by the considerations outside the record. In other words, the trial judge does not sit as a 7th juror with veto power. His setting aside a verdict must be supported by the record or by the findings reasonably amenable to that judicial review. Not every verdict which raises a judicial eyebrow should shock the judicial conscience. Let's see. As the 3rd District stated in Reddy, A trial court is never free to reduce a verdict by remittitor to that amount by which the court itself considers the jury should have allowed. It can only be reduced to the highest amount to which the jury could properly have awarded. Although the defendant has asked through the motion for a remittitor of the various awards, it also posits that the remittitor is not possible in this case because the awards were so arbitrary that they cannot even be used as a reliable measure for a remittitor. Based on that concession, and the absence of any evidence or understandable methodology presented by the defendant as to what it contends the verdict amount should have been, the court should decline any remittitor. I realize I'm saying remittitor and I'm supposed to say remittitor, but it sounds more fun to say remittitor. Pleading requirements. We've already, look at this, we've already reached page 28. We're like a third of the way through. I'm going to need some more water. I love the phrase judicial eyebrow. Yes. I think we should change that, Ray, to be judicial monobrow or unibrow. I think it should be judicial unibrow. Let's petition the court, see if we can do that. Defendant repeats its frequent, erroneous lack of pleading assertion, this time contending that intent to harm was not pled in regard for the claim to punitive damages. This again ignores that a complaint, as a pleading, is merely a tentative outline of the position which the pleader takes before his case is fully developed on the facts through discovery and evidence. The punitive damages pleading requirements are found in Section 768, Florida statutes. The damages limitation provisions, including the intent to harm element, are in Section 768.73, Florida statutes. Defendant conflates these separate requirements. Defendant demonstrably was not surprised that intent to harm was part of the plaintiff's case and that a question about it was coming in the second phase of the bifurcated punitive damages proceeding. Dr. Neuberger testified that defendant's personnel intended to harm the Kowalskis, a point defendant complains about in the motion at pages 41 through 42. Issues affecting all claims. The court did not err in the application of Chapter 38 immunity. Defendant concedes there were limitations on the types of conduct that will obtain immunity under Chapter 39. Defendant is not maintaining that statutory immunity would give it a free pass to torture a child or place a child in a dungeon. Defendant just disagrees with where the court drew the line. The court crafted a thoughtful omnibus order concerning Chapter 39 immunity relatively early in the case. The court applied the standard set out in Urquhart v. Helmick and Ross v. Blank, requiring only that the defendant have reasonable suspicion before reporting child abuse. The court's omnibus order noted that the Urquhart and Ross decisions appeared not to have considered the separate and coexistent good faith requirements set out in Chapter 39. Nonetheless, the court applied the law as it exists and entered summary judgment on many of the plaintiff's claims as a result, i.e. false reporting, abusive process, malicious prosecution, civil conspiracy, intentional interference with the custodial parent-child relationship. The causes of action that survived beyond the court's application of Chapter 39 immunity were those that could not be considered to have been authorized or required by Chapter 39. Those included false imprisonment, battery, medical malpractice, negligent training, fraud, and intentional infliction of emotional distress. For each of these claims, defendant cannot and has never been able to point to anything in Chapter 39, the dependency court's orders, or DCF directives to authorize or require its actions. To take a couple of examples. 1. At no time did DCF or the dependency court authorize Maya's false imprisonment between October 7th and 13th, and neither could defendant justify its conduct through Chapter 39, which expressly prohibits a hospital from detaining a child beyond 24 hours absent a court order, which it did not have. 2. Similarly, a hospital or any sheltering institution cannot batter a child, and it is absurd to suggest the battery of a child is or was authorized by the Florida legislature or the dependency court. And 3, the sheltering hospital is not free to commit medical malpractice on a child simply because it has been entrusted with the child's care and custody by the dependency court. I'm dying here. 1 second. This part is fire. This is really good. By the dependency court. None of these causes of action and none of the claims that went to the jury are authorized or required under Chapter 39. Moreover, defendant cannot point to the manifest weight of the evidence to suggest otherwise. Having made this determination for each of the plaintiff's causes of action, whether the particular actions were subject to Chapter 39 immunity, the court then conducted the trial by carefully excising from the evidence any avoidable mention of the dependency court proceedings, the DCF actions, and child abuse reporting. At defendant's urging, the court read the jury a 10-page instruction detailing the visitation rights of the Kowalski family and the rights and duties of the defendant hospital under the various orders entered by the dependency court. The court gave this instruction to the jury in hard copy for its deliberations. Plaintiff objected to the instruction on multiple occasions based on plaintiff's perception that the detailed instruction gave the defense exactly what it wanted, a basis to argue that its actions were all immunized. Notably, and favoring the defendant, the court kept away from the jury. The defense counsel in this case had participated heavily in persuading the dependency court to enter the various orders and impose further restrictions on the Kowalski family, orders and restrictions defendant sought to use as a shield in this case. In short, defendant had every potential benefit of Chapter 39 and its immunity provision, and the jury was repeatedly instructed that Johns Hopkins All Children's Hospital had absolute immunity for its reporting of the suspected child abuse on October 7th and October 9th. The court did not err in allowing the plaintiff's attorney to use the per hour, per component closing argument. Motion 35. Florida does not have a defined method for calculating non-economic damages. As the 5th District recently stated, the Florida Supreme Court has acknowledged the difficulty in measuring non-economic damages, and there is no mathematical or technical measure for them. This language is aligned with the Florida standard jury instructions and adheres to the long practice in Florida of allowing plaintiffs to argue for calculating non-economic damages utilizing a unit of time measurement. In Purdue, the court upheld the plaintiff's use of figures representing a mathematical computation, reducing pain and suffering to a calculation in money on a per diem basis during closing arguments. The 2nd District held that based on the evidence in the record, the trial court did not abuse its discretion by allowing the plaintiff's counsel to use a daily unit of time multiplied by what he admittedly was a very arbitrary figure to calculate the plaintiff's pain and suffering damages. Likewise, in Ratner, the 3rd District held that the use of a chart and calculations to show manipulation of the number of days of the plaintiff's remaining life expectancy by a value for daily monetary pain and suffering was permissible. So doing the math for the jury on a chart is allowed. The court found that the weight of the authority favors allowing the use in argument of a mathematical formula such as suggesting amounts in a per diem basis when damages for pain and suffering are involved. Also, notable in the Florida Supreme Court's decision in Allred Supra, there, the plaintiff's counsel said during closing argument, "I don't believe in my mind and my heart that $2.50 a day for what this lady has got to go through and what she is going to go through in the past is too much." The trial judge granted a motion for a new trial on several grounds, including that the statement during the closing arguments, and the 2nd District affirmed. In quashing the 2nd District's decision, noting that the verdict does not appear to be against the manifest weight of the evidence, the Supreme Court stated, "Obviously, in a personal injury action where damages are awarded, the injured party is entitled to fair and just compensation for the injuries sustained. However, it is not always possible, absolutely possible, to determine with complete assurance what may constitute full compensation."
Roro just sent a super sticker with 19.99.
Roro, thank you very much for the super sticker. I appreciate that. However, it's not always possible to determine with complete assurance what may constitute a full compensation. Each case must be considered on its own facts, since in most instances there is an element of speculation without the exactitude of a measuring yardstick. Argument of the plaintiff's counsel to the jury regarding various elements of damages, especially where pain and suffering are involved, based on a mathematical formula of calculable value on a per diem basis, may be helpful to the jury in its final deliberations. Yet doing the math for them could help the jury. Let's see. This is more case law that supports this. Let's see. Approving trial court's decision to allow plaintiff's counsel to place on a blackboard a mathematical formula which suggested the jury could use in computing the money value in the past, present, and future pain and suffering of a plaintiff. The foregoing cases addressed non-economic damage calculations on a per diem basis, but the Supreme Court did not limit permissible calculations to a daily rate, noting that a mathematical formula of calculable value on a per diem basis may be helpful. Consistent with that, a Fourth Circuit case allowing a mathematical formula using an hourly rate based on the evidence presented in the case is right there. In summary, there is no support in Florida for case law prohibiting a daily, hourly, or other mathematical calculation that is understandable and supported by the evidence. Importantly, defendant did not suggest a different hourly rate or offer an alternative methodology for calculating damages. Defense counsel told the jury to use your common sense and suggested a tune-up for Maya on a physical therapy at a cost of $15,000 for 1 year and psychotherapy at a cost of $200,000 or $250,000. There was no evidence, expert testimony or otherwise, offered to support this. Likewise, on the wrongful death claim for Beata, defense counsel offered no methodology, but simply suggested a range of $500,000 to $1 million, or $1.5 million, even per person, would be something that would be fair and adequate. Overall, the defense counsel said, and in terms of totals for this, $3 million, $4 million, I think that would be more than fair. That was Mr. Shapiro. These suggestions, unsupported by any evidence, gave the jury no guidance at all as to range for the multiple categories of damages itemized on the verdict form. Defendant's failure to offer understandable alternative damages methodology is akin to the Supreme Court's statement. It is difficult for a party to challenge an award as excessive after the fact when that party declined to offer any guidance to the jury at trial. When the defendant does not assist the jury in establishing a range or a verdict, it is more difficult for the defendant to later suggest that a verdict below the plaintiff's request is somehow a verdict which exceeds the maximum limit of reasonable range in which the jury was free to operate. The decision to grant defendant's motion for a directed verdict on the negligent training claim at the end of the trial caused no confusion. Defendant admitted the evidence was relevant to the punitive damage claims. As discussed and quoted above, the defendant ultimately recognized that negligent training was relevant to the punitive damage claim, so the evidence was properly admitted, and the defendant cannot now argue otherwise. So also was the evidence of the Florida licensed Joint Commission accredited facility having to comply with the requirements discussed in detail below. Further, Florida statute states hospitals have a duty to assure comprehensive risk management and to the competence of their medical staff. Then, Section 766 imposes a duty on the hospital for the supervision of the medical staff and hospital personnel to the extent necessary to ensure that such medical review and risk management processes are being diligently carried out. The section concludes with, each such facility shall be liable for the failure to exercise due care in fulfilling one or more of these duties when such failure is a proximate cause of injury to a patient. So contrary to defendant's argument, it is liable for the lack of supervision as well as training, even if the person was within the scope of their employment. The individual's actions and omissions being within the scope of their employment or agency does not violate responsibility of the entity for its institutional responsibilities and failings. Plaintiff discusses defendant's further liability under Florida and federal law below. 4. The grant of additional time to plaintiffs caused no prejudice. Defendant was not limited in presenting its case other than perhaps by its counsel's vacation plans. Mr. Shapiro's his vacation's been mentioned 3 times. I hope it was a good one. Mr. Shapiro, send us pictures. We'd love to see. Ahead of the trial, never mind, I don't want to see. I changed my mind. Ahead of the trial, the court, cognizant of the burden on the jury and the public servants of Sarasota County, initially informed each side that they would have 50 hours available to present their case in chief. Defendant expressed some reservation about the 50-hour time limit at the pre-trial hearing, asking for 60. And the court increased the available time for each side to 55 hours. During trial, the court granted both sides an additional 4 hours. Plaintiff then requested additional time to allow proper cross-examination of the defendant's remaining witnesses and a brief rebuttal case. The court then granted both sides an additional 5 hours, with plaintiff receiving 2.5 hours for the remainder of the defense case and additional 2.5 hours for rebuttal. The court made clear that whatever time the plaintiff reserved... Why is that doing that? Okay, we'll fix it. The court made clear that whatever time plaintiff reserved by limiting cross-examination during the remainder of the defense case would not roll over and add to the time allotted for plaintiff's rebuttal. Shortly thereafter, and with no pressure being applied from the court or plaintiff's counsel, defendant decided to rest, having used only 41.2 hours of its available 64 hours. The court confirmed with defense counsel on multiple occasions, on the record, the defendant was not resting due to perceived time pressure. In fact, the court had already advised the jury that the trial necessarily may be extended into the following week, the week beginning November 13th, and beyond the November 9th deadline announced to the veneer at the outset of the trial. Given this backdrop, defendant's claim that it was prejudiced by the court giving additional time to both sides during the trial is without merit. Dr. Eli Newberger's deposition testimony over objection. Defendant belatedly objects to the introduction of Dr. Eli Newberger's testimony on the claimed basis that the standard of care issues in this case concerning the healthcare providers at Johns Hopkins All Children's Hospital are not, and never have been, issues of child abuse. Defendant continues, after plaintiff withdrew any claim concerning Munchausen by proxy, the subject of child abuse had little or no relevance in the case. The first hurdle that defendant cannot clear is preservation. Ahead of Dr. Newberger's deposition testimony being read to the jury on the morning of October 2nd, defendant re-raised certain objections to Dr. Newberger's deposition testimony, and the court made rulings in the defendant's favor. Defense counsel asked the court to reconsider the defendant's objection to Dr. Newberger's commentary that Sally Smith's acts were intentional and malicious, and his comment that the defendant's actions in concert with Dr. Sally Smith constituted an unlawful act. The court agreed with defendant and excised Dr. Newberger's comment that Smith's conduct was an intentional act, as well as Dr. Newberger's comment that this was, by definition, constitutes conspiracy. Yet, in its motion, defendant complains that Dr. Newberger was allowed to become a jack-of-all-trades expert who opined on the unlawful acts and conspiracy of the doctors of Johns Hopkins All Children's Hospital. Defendant neglects to mention the court's last-minute rulings and excise testimony regarding the unlawful acts and conspiracy that defendant complained of. Given the court's demonstrated willingness to excise such testimony, defendant is either A, complaining of a testimony that was not presented to the jury, or B, is complaining that defendant, failed to address other objectionable testimony with the court, but now raises the issue for the first time, having failed to preserve the issue, since defendant cannot point to any request it made to the court to excise additional testimony. Preservation issues aside, defendant's arguments are flawed. Dr. Newberger's testimony was relevant and admissible for at least 3 reasons. First, Dr. Sally Smith's role as the hospital child abuse pediatrician and rotation director for Johns Hopkins All Children's Hospital residency program was a central issue in the case. Dr. Smith cannot appear in a case and cannot appear here without putting the question of child abuse at the forefront. The question of Dr. Smith's apparent agency status was the subject of one of a few special interrogatories on the verdict form. Dr. Newberger's testimony on the role of the child abuse pediatrician, the discernment between treating physician and state's contracted medical director conducting an investigation, were critical to the jury's understanding the determination of Dr. Smith's apparent agency. Second, in discussing plaintiff's withdrawal of any claim concerning Munchausen by proxy, defendant fails to account for the way in which the trial unfolded. Defendant's case in chief, throughout the testimony of multiple witnesses, focused on Beata Kowalski's alleged bad acts and willingness to accept the advice of Maya's treating physicians to administer ketamine at levels defendant considered outside its standard of care. After multiple witnesses testified in this fashion, focusing, for example, on the amount of ketamine administered in Mexico in 2015 and on Beata's alleged failure to follow up on Tampa General Hospital's recommendations for further physical and cognitive behavioral therapy in 2015, the court asked the parties whether Munchausen by proxy was at issue. The court's inquiry occurred on October 20th and October 23rd during the defendant's presentation of its case, not the plaintiff's. The court said, I want to begin today, this is Judge Carroll, I want to begin today, or I guess our next issue today, since we've already had a first issue, is to pick up where we were discussing at the end of the day on Friday, which I thought was a very illuminating discussion, but certainly Mr. Anderson and Mr. Hunter weren't in the room. I hope each side has an opportunity to discuss amongst the individual teams, and hopefully with each other, the issue that was discussed, i.e. whether there was going to be a claim for damages associated with Munchausen by proxy from the plaintiffs, and whether the defense had some further statement or clarification as to whether it was contending or not contending that MK did or did not have or does not have CRPS. If you remember this conversation, Nick Whitney was there, and who was he up against? Was Shapiro? Because Mr. Anderson and Mr. Hunter were gone. And Nick did an amazing job holding his own on this one. Critically, when Dr. Newberger's testimony was presented by deposition, defendant was routinely attempting to establish that Beata had mistreated her daughter by allowing excessive medical treatments and by refusing proper medical treatments offered by defendant and others. Third, an expert is permitted to opine on the ultimate issue. Regardless of the alleged withdrawal of any claim concerning Munchausen by proxy, the subject of alleged child abuse was material to this case due to the defendant's actions. The entirety of the JHACH medical record covering Maya's October 7th to January 14th admission was entered into evidence as Joint Exhibit 1001. The JHACH medical record is replete with defendant's alleged diagnosis of Munchausen by proxy and suspected child abuse. At no point did defendant suggest that its own medical records should be excised of any reference to Munchausen by proxy or suspected child abuse, and those terms and the corresponding allegations were before the jury no matter how plaintiff presented his case. Next. You're going to go back and listen to the first 20 pages at two times speed. I'm trying not to read too fast because it gets confusing. I don't think I could do it at 2 times speed. Furthermore, given defendant's reference to Maya as ketamine girl, Dr. Sally Smith's text messages stating that Maya was making psychological mistakes because, fortunately, at 10 years old, she can't perform the charade effectively 24/7, defendant continued to place child abuse at the forefront. Given Dr. Sally Smith's further statements that she wouldn't put anything past her mother, risk management notes indicating that Maya was surveilled for nearly 48 hours to see if she can walk on her own and to see what she was able to do when no one was there, and testimony that Beata improperly and dangerously rewarded Maya with Valium, plaintiff was entitled to rebut these repeated and ever-present allegations of child abuse by Beata on her daughter, Maya, with a testimony of child abuse pediatrician. The overwhelming weight of the evidence demonstrated the abuse that Dr. Neuberger testified to. That Dr. Sally Smith and her fellow physicians at JHACH preposterously convinced and cruelly executed a separation test because they wouldn't put anything past her mother, and Maya wouldn't be able to keep up the charade effectively 24/7. Defendant was not precluded from calling its own child abuse pediatrics expert, Dr. Randall Alexander, nor from calling Dr. Sally Smith live, which it did. Through each of these witnesses, defendant attempted to explain away Dr. Smith's horrific actions and rebut Dr. Neuberger's testimony. To the extent Dr. Neuberger testified that Dr. Smith had performed unlawful acts, which plaintiff disputes given the court's last-minute rulings to excise that testimony as described above. Defendant elicited testimony from both Dr. Alexander and Dr. Sally Smith that not only were her acts lawful, but required, given her role as medical director of the child protection team. Defendant waxes negative on the Dr. Neuberger's age and experience, but then says it does not question his qualifications to express opinions despite his age and limited recent experience. The things defendant argues about are things it should have addressed in its cross-examination of the doctor. Defendant then says the issues concerning its conduct and the multiple torts committed have never been about child abuse. Those issues involved false imprisonment, battery, and the intentional infliction of emotional distress. Defendant still does not get it that when done to a 10 or 11-year-old girl, those acts are child abuse. Motions for the intentional tort claims of Maya Kowalski. Defendant acknowledges the court gave a non-duplication of damages instruction, but complains the court often did not explain the non-economic damages could not be duplicated. Assuming this was preserved, when the plain language of the instruction refers to damages, that means all damages. Consistent with plaintiff's suggestion and the non-duplication instruction, the jury was empowered to allocate the damages over several torts it found defendant committed and it damaged Maya. Defendant cites no law that a jury must allocate damages caused by multiple events among those events with pinpoint accuracy, and in any event did not object to plaintiff's approach. False imprisonment. The claim for false imprisonment from October 7th to 13th. Defendant's false imprisonment arguments overlap, and so plaintiff discusses some common issues followed by specific factual rebuttals and then damages. Hospital liability for actions applicable to all tort claims. Defendant's myopic focus on doctors ignores that the initial week-long confinement at the hospital and other imprisonments were orchestrated and carried out by defendant's staff, not limited to the physician who first saw Maya. The group included risk management personnel, multiple critical care intensivists, and some serving on committee leadership positions at JHACH, nurses and social workers, the majority of whom testified at trial. The group orchestrating this imprisonment also included Dr. Sally Smith, who also served on JHACH committees, as an apparent agent of the hospital. Defendant's position that no true managing agent was involved in the torts committed on Maya continues to miss the point that the jury was entitled to find that the defendant's managers and other personnel, risk management department, orchestrated the conduct toward the Kowalski family, and that under the state and federal law cited next, the governing board and body of the defendant hospital is always ultimately responsible and liable for that conduct. As this court's second order on the punitive damages recited, and the jury heard, Catherine Beatty testified she was directed by defendant's risk management department to perform the actions the jury found falsely imprisoned and battered Maya. Defendant's apparent excuse that it staffed its risk management department with low-level personnel is no excuse for its irrelevant, and is irrelevant given Florida statutory law. Florida law mandates that every licensed facility shall, as a part of its administration functions, establish an internal risk management program. Florida statutory law. More important for this purpose, the next section states, the internal risk management program is the responsibility of the governing board of the healthcare facility. Not that it would help defendant, because it is liable as a matter of law, but there is no record evidence to support defendant's assertion that its risk management department was staffed with low-level personnel, nor is there record evidence employees acted without the approval and not under the directives and standards of or policies and procedures of defendant's governing board. Defendant failed to call any of the involved risk managers to testify, nor did defendant call Jackie Crane, the hospital's senior counsel at the time. The risk management department reported directly to Ms. Crane, and neither she nor the risk managers nor anyone else testified to the allegedly low-level status of the employees. JHACH allowed to direct the low-level status of employees. JHACH allowed to direct Ms. Beatty, direct medical decisions and treatment, interpret dependency court orders, and authorize multiple false imprisonments and batteries. These risk managers received direct reports that Maya felt she was being lied to by hospital personnel about her mother and other issues. The defendant and the risk managers ignored and shelved those concerns. The court stated on the record, after seeing these risk management notes, that defendant's conduct was outrageous. Section 395 goes on to specify the areas for risk management, including patient care, medical care, personal and social care. The jury heard ample evidence of the defendant's failings in these areas. Again, these failures are the responsibility of the defendant's governing board, and thus the defendant. Promulgated under Section 395, Incident Reporting System mandates, at least quarterly or more often as may be required by the governing body, the risk manager shall provide a summary report to the governing body which includes information about activities of risk management as defined herein. For easier reference, regulations and statutes cited herein are filed under Plaintiffs' Notice of Filing of Hospital Regulations. That's the huge document that dumped earlier in the day. As discussed below, defendant failed to do this, including while Maya was there. Similarly, the law states that the licensee shall have the rule states that the licensee shall have a governing body responsible for the conduct of the hospital as a functioning institution. Let's see. Tracy Collins says, just got here, so you may have already read it, but Ethan Shapiro was interviewed tonight on Patreon. Nobody Should Know podcast. I did not know. Apparently he's back from his vacation. I think it was a shorter one. Did he send pictures? Tracy, thank you very much. I'll have to look for that and see what he has to say. Let's see. Liability of healthcare facilities mandates that hospitals have a duty to assure comprehensive risk management and competence of their medical staff and personnel. Each facility shall be liable for a failure to exercise due care in fulfilling one or more of these duties when such failure is proximate cause of injury to a patient. In sum, the suggestion that defendant can avoid responsibility for the actions of its risk management department would flaunt the very Florida law under which defendant is permitted to operate. The evidence demonstrated clearly and convincingly that the actions of the defendant's risk managers, who reported directly to the defendant's chief counsel officer and through her, its president, met the law and standards. Federal law also makes the hospital, through its governing board, responsible for actions at the hospital. Hospitals such as the defendant that receive federal funding through Medicaid or Medicare must meet the government requirements for program participation, including certification of compliance with the health and safety requirements called conditions of participation. It's got a link that says Joint Commission. You can smell where that's going, huh? A foundational condition of participation with the defendant JHACH had to all times comply in order to receive a dollar of federal funding was that it had to have an effective governing body that was legally responsible for the conduct of the hospital. Another condition for participation is that the hospital must develop, implement, and maintain an effective, ongoing, hospital-wide, data-driven quality assessment and performance improvement program. The hospital's governing body must ensure the program reflects the complexity of the hospital's organization and services. As noted, hospitals must be certified as being in compliance. Florida statute on hospital license inspection provides that the Agency for Healthcare Administration shall make or cause to be made such inspections and investigations as it deems necessary, including inspections directed by the Centers for Medical and Medicare Services, CMS. Again, this is necessary for a hospital to receive funds, federal funds. Section 395 then provides that the agency shall accept, in lieu of its own periodic inspections for licensure, the survey or inspection of an accrediting organization. The Joint Commission, TJC, is one such organization. Federal deemed status fact sheet is attached, notice of filing. Thus, the inspections discussed at trial were required for defendant to receive federal funds. That is why the immediate jeopardy finding was so significant. Just as Florida law makes the hospital's governing body responsible for the conduct of the hospital, the Joint Commission requirements mandate that the governing body is ultimately accountable for the safety and quality of care, treatment, and services. The in lieu of language does not divest AHCA, or AHCA, or CMS of the authority to conduct investigations or actions. Hence, the adverse 2017 report emanated from AHCA and the immediate jeopardy letter from CMS. Defendant continues to try to hide from and compartmentalize its immediate jeopardy finding. Its response, an incredible request for sanctions, asserts Dr. Corcoran was mistaken about the September 8, 2018 date. The January 2019 survey refers to failings resulting in a September 20th, 2018 finding of immediate jeopardy. Dr. Corcoran should not be the target of defendant's misdirected fire. He is simply referencing CMS's survey and its express language. The 50-page survey catalogs numerous failings, including that of the Senior Director of Patient Safety and Quality, and did not have access to any risk management reports in the 15 months she had been in her position, a major violation of the requirements discussed above. The survey continued. Additionally, she also stated that all adverse medical incidents remained with the risk manager, and nothing was done. She indicated the facility has no historical data on objective indicators of quality of care that has been tracked, trended, or analyzed, such as unplanned returns to surgery, patient deaths, or morbidity and mortality statistics by physician. The CEO confirmed these findings. The defendant hospital is responsible, as these laws and standards mandate, and defendant's systemic and prolonged failings long predated the immediate jeopardy. As a result of the governing inspector's findings, the defendant fired 8 top executives. Defendant's failings were structural and led to immediate damage to plaintiff's family and others. I see you guys are having fun in chat. All right. They fired a bunch of people. Let's see. Defendant's response attached 2015 and 2018 Gold Seal certificates, as if those would blind anyone from seeing its catastrophic failings before, after, and during that time period. The gold stars do not in any way mean that defendant's profound systemic failures, as evidence that the governmental inspector's reports did not happen. They clearly and obviously did. Exhibit 2815 shows defendant was in immediate jeopardy for failings in 4 areas. And it and the survey and the findings were retrospective, not prospective, or limited to hard issues as defendant represented. The additional exhibits, including the February 2017 AHCA report, showed defendant's organizational deficiencies, including those dealing with parents, and again, was retrospective, including those dealing with parents, and again was retrospective. Sorry, I sort of left you hanging there. To the public, CMS, AHCA, and the Joint Commission, defendant recognized and acknowledged its failings, but now it attempts to rewrite history by contending that there was no hospital-wide failure, but rather the issues were limited to the HEART program. Multiple internal memoranda and even town hall meetings that were recorded and saved on the hospital's media system demonstrated that the defendant acknowledged the issues were systemic and cultural. Defendant documented its dark history of retaliating against employees and healthcare providers who spoke up about mistreatment of patients, and even undertook a hospital-wide effort to re-educate its employees in an effort to end its culture of retribution, but not until 2018. Unfortunately, Maya and Beata fell victim to all of this. In sum, defendant's conduct violated Florida law, federal law, and the Joint Commission standards it voluntarily sought to be accredited under. Plaintiff notes
Hippo Lover just sent a super sticker with 5.
Thank you, Hippo Lover. Thank you so much. Love having you here. Plaintiff notes that Florida law provides a bench of a federal requirement is not admissible as evidence in a malpractice case. That is of no moment here because defendant violated Florida and TJC mandates. Defendant's failings were admissible as to its liability in the false imprisonment and battery torts, and defendants invited what happened when it presented expert Anderson's false evidence. He did open the door for this one in a big way. Okay, factual questions for the jury. We're already at page 50, guys. We're just tearing through this. Defendant makes factual arguments on issues within the jury's province. For example, defendant disputes Maya's version of the photography session, but that was the jury's call. The jury was entitled to value the trauma of the 11-year-old girl being forcibly stripped and photographed differently from the defendant. Defendant reverts to talking about the release form or the consent signed by JHACH and on Maya's admission, which actually titled Consent for Routine Diagnostic Procedures and Medical Treatment. The jury was entitled to find photographs defendant did not place in Maya's medical file were not taken for medical reasons, but for defendant's purposes, especially considering that Beatty admitted as much during her testimony. Defendant suggests that the court erred in not ruling on this as a matter of law, but defendant did not request such ruling and thus waived this argument. Further, defendant abandoned this argument and did not attempt to persuade the jury in closing argument that the photographs taken by Beatty on January 6 were covered by the medical consent form signed by JHACH on October 7th the previous year. The court repeatedly cautioned that defendant that it took a dim view of the defendant's argument that consent form covered such offensive conduct because the photographs would have to be for medical purposes, and the photographs were never placed in Maya's medical record. Damages. I need more water. I think we're 2/3 of the way through. I think we've got about 50 plus to go. Is it over 100? Oh my goodness. I think some of the end pages might not be as heavy. It's 88 pages. I like that, Kim. I'll take that answer. Okay, damages. As discussed above, the 3 false imprisonments, batteries, and intentional infliction claims were part of a continuous ongoing pattern of conduct harming Maya over 3 months. Plaintiff suggesting allocating the damages to compensate for these harms among the claims. Defendant has cited no law requiring mathematical precision in allocating damages among the torts in this unique situation. Thus, the jury was free to evaluate the total damages and allocate them. The jury was instructed not to duplicate damages, and that instruction was not limited to non-economic or economic damages. This is sort of a repeat. Having suggested no other methodology or virtually no basis for conclusatory alternative numbers mentioned in closing, defendant should not be heard to attack specific figures the jury awarded under the different claims. The question should be whether the jury's award was within its discretion in this unique case, and defendant has failed to show it was not. Similarly, on punitive damages, defendant has not shown the award was excessive under the state or federal law given the outrageousness of the conduct, the egregious corporate failings for which it is liable under state and federal law per above, and defendant's assets. Motion for a new trial remediator on excess compensatory damages. The facts and the circumstances presented to the jury for this claim, false imprisonment from October 7th to 13th, show the total amount awarded for compensatory damages of $5.563 million, inclusive of the economic and non-economic damages, was not excessive. Samantha Terry, thank you for the super chat. Deer Park Water, please sponsor the channel hydration fund. Yes, I think I've drank about a gallon of their water today, at least. I probably should have at least 2. Defendant's several actions directed toward Maya, summarized above, combined to cause the awarded damages. As discussed herein, there was nothing wrong with the jury allocating damages over the claims, and they were instructed not to duplicate damages. Conversely, defendant presented no evidence that would support a remediator of this award under the factors of section 768 as follows. We're going to skip the 2 instructions. Oh, wait, no, we're not. Defendant presented no evidence that shows the verdict is indicative of prejudice, passion, or corruption on the part of the jury. The size of the amount awarded for this claim cannot be considered as evidence of this. Defendant's suggestion that the verdict resulted from the leadership of juror number 1 is speculation, as discussed above. And in plaintiff's response, or page 2, and in plaintiff's response to the defendant's motion for a new trial based on purported misconduct of this juror. The amount awarded for economic damages was consistent with the plaintiff's evidence of such damages for this claim, which was not disputed by the defendant. See the testimony of Doctors Chopra, Kirkpatrick, Bifulco, and economist Christy Kirby. Economist. It was economist. Is that a better word? Economist. I like my pronunciation way. For the non-economic damages, the plaintiff ordered Maya's unrebutted testimony of her injuries. Plaintiff also offered to the jury, during closing argument, an understandable mathematical formula to calculate the value for the elements of an injury identified in verdict form. Question number 3. Defendant offered no evidence of damage or of any alternative method to calculate non-economic losses. Consequently, there is no showing in the record that the jury ignored evidence or misconceived the merits of the case related to the amount of damages recoverable for this claim. The total compensatory damages awarded for this claim in response to questions 2, 3, and 4 on the verdict form consisted of economic and non-economic damages for the elements identified in the jury instructions and on the verdict form. Those instructions followed the standard jury instructions, and the defendant did not object. There is no evidence that the jury took improper elements of damages into account or arrived at the amount by speculation and conjecture. For the reasons discussed in Section B above, the amount of the compensatory damages awarded, totaling $5.5 million, bears a reasonable relation to the amount of damages proved and the injury suffered. Again, defendant offered no evidence of its own as to reasonableness for this claim. For the reasons discussed in response to Section B above, the amount awarded for this claim is supported by the evidence and could not be adduced in a logical manner by reasonable persons from the evidence and from methodology proposed by the plaintiff's counsel, the only methodology proposed to the jury. For these reasons, there is no record of any impropriety in the award, and no evidentiary basis under Section 6768 by which the court could remit the jury's awards and economic, non-economic, and compensatory damages for this claim. For the court to do so on this record would be for it to improperly choose an amount which the court itself considers the jury should have allowed. Finally, as the defendant has repeatedly noted, this case is unique, and consequently there are no verdicts in other cases that are fair comparisons to the verdict here for non-economic damages for this claim, or that provide a reliable basis for remitter of the award. Renewed motion for the directed verdict on punitive damages, or in the alternative motion for a new trial on the grounds of manifest weight of the evidence concerning punitive damages. That's a big motion. As shown above, the jury was entitled to find the actions defendant directed through Catherine Beatty and others, for example, through its own risk management department, warranted punitive damages. Florida and federal law, the Joint Commission standard, make defendant liable for these actions and failings consistent with the jury's verdict. Motion for a new trial on the amount of punitive damages or remitter. Punitive damage awards are peculiary. Can you say that word for me so I know I'm saying it right? Peculiary? She can't say it either. It's not just me. Mrs. R.A. is struggling. Peculiary. There's like an extra U in there every time I say it. We're going to strike this. It is a tough word, Krista. I'm struggling with it. Somebody give me a pronunciation guide. I can say peculiar, but I can't say peculiarly. Peculiar. You add the ly on the end, and it becomes impossible. It's like a tongue twister. It's left, anyway, whatever it is, it's left to the discretion of the jury as a degree of punishment to the inflicted must always be dependent on the circumstances of the case. Let's see, we're going to go through here. The instructions used by the court for both the first phase and second phase of the punitive damages claim used by the standard jury instructions. As discussed above, the amount of compensatory damages awarded for the false imprisonment claim between October 7th and 13th, for which the jury found by clear and convincing evidence that punitive damages were recoverable, totaled $5.5 million. The court agrees the amount is supported by the evidence and accepts the jury verdict that the defendant acted with the intent to harm Maya Kowalski. Then the $15 million of the punitive damage award for this claim satisfies Florida statutory and due process standards. The punitive damage amount is less than 3 times the compensatory damages limitation. It therefore bears a reasonable relationship to the injury suffered and cannot be said to be out of reasonable proportion to the malice, outrage, and wantonness of the defendant's conduct. The punitive damages amount is also well under the $1 billion the defendant assets shown by undisputed evidence and therefore will provide deterrence but not economic castigation or bankruptcy. For these reasons, the punitive damage award also satisfies the prongs 1 and 2 of the federal due process test. Regarding the third prong of the federal test, defendant tacitly recognizes that this case is unique and consequently there are no comparable cases. Nonetheless, it may be some limited value to the court to consider the $30 million punitive damages award on approximately $10.5 million in compensatory damages, which was upheld in Schaff versus R.J. Reynolds Tobacco Company, a smoker's case which, as noted above, involved much less egregious circumstances of an adult who consciously chose to smoke in the face of known dangers, rather than a 10-year-old child who was intentionally mistreated. They got more case law discussing constitutionality of a 4-to-1 punitive to compensatory ratio, but declining to oppose a bright line ratio in that case. Did I miss a comment here? You guys are like talking about music. How many of you have fallen asleep already by show of hands? Okay, that's good. The claim for false imprisonment from October 18th to October 20th, motions for directed verdict, new trial and remittiture of compensatory damages. This is the time period where she was in there being monitored. Plaintiff adopts the arguments made above. For the first time in this case, defendant argues that the covert video surveillance was not actually treatment of Maya. It was primarily a non-invasive diagnostic test. What else was it for? Despite defendant's novel argument, none of JHACH's physicians testified that the covert video recording was primarily a non-invasive diagnostic test, nor did Dr. Paola Dees testify that she made the decision to covertly record Maya, and no one ever produced a plausible explanation that if this covert video recording was done for medical diagnostic and treatment purposes, why was there no mention of it in the diagnostic test in Maya's medical records? No results, no outcome, no findings, other than a lone mention that Maya was transferred to a room on 7N with video monitoring capability. Defendant's argument is not drawn from the evidence at trial. Rather, defendant's novel argument is a rewriting of the evidence defendant wishes existed. The tell is that nothing in this novel argument is cited or tied to any testimony or particular evidence adduced at trial. Moreover, defendant all but admits that the jury's finding of liability on October 18th and October 20th, false imprisonment, was the correct result. In retrospect, at least Mr. Kowalski could have been informed of this test. However, by not informing JHACH or Beata of this primarily non-invasive diagnostic test, defendant usurped the medical decision-making rights that dependency court expressly reserved for JHACH and Beata during the dependency proceeding. By the defendant's belated recognition that it should have informed JHACH of the covert video recording, defendants admits that to definitional false imprisonment, since the primarily non-invasive diagnostic testing was done without legal authority in circumstances that were unreasonable and unwarranted. Lastly, defendant attacks the jury and argues that the jury clearly did not review the video that is in evidence. But defendant overlooks that the jury only saw portions of the 48-hour video. Plaintiff presented 4 clips, and defendant presented only 2, attaching a brief index to its motion, too little, too late. Appendix B to the motion should be disregarded because the appendix was not submitted to the jury, and the standard here is to demonstrate that the verdict was against the manifest weight of the evidence. The jury cannot be faulted for not reviewing the entirety of the 48-hour video that the defendant did not move to admit into evidence, and defendant's 2 clips, totaling less than 3 minutes of covert video footage, hardly overcame Maya's compelling testimony about the ways in which she was mistreated in that room over those 48 hours. As also discussed earlier, the jury was entitled to apportion the damages of these different events that gave rise to common injuries among the claims, and was instructed not to duplicate damages. Defendant provided the jury with no real alternative measures of the damages. It should not be heard to try to nitpick how the jury allocated particular awards. Renewed motion for directed verdict, or in the alternative, a motion for a new trial on a verdict against the manifest weight of the evidence on punitive damages or remittiture. These get a little repetitive here, so we're going to try to fly through them. Plaintiff adopts the arguments made in the response to the initial false imprisonment claim, and again notes the defendant had no medical purpose for further isolating Maya. The evidence was not made part of her medical chart. Defendant's risk management department that orchestrated this and the stripping and photographing session is deemed part of the hospital management, and defendant is responsible for them under state and federal law. Defendant says the punitive verdict for this claim was $15 million, but the verdict question 4 awarded $10 million. As emphasized above, the punitive award did not exceed the statutory cap 3 times compensatory damages on this claim. The claim for false imprisonment on January 6th. What exactly the defendant's argument to justify the false imprisonment, or more importantly at this point in time, to demonstrate that the jury's finding of liability on the July 6th false imprisonment was contrary to the manifest weight of the evidence? First, defendant suggests that it should have immunity for this false imprisonment for no other reason other than the false imprisonment occurred in close proximity to a dependency court hearing. Defendant offered no evidence at trial and does not even suggest in its motion that the dependency court somehow sanctioned this false imprisonment. Next, defendant challenges Maya's account of the events, that she was stripped naked during the false imprisonment to change into her court outfit. But then defendant admits that there were admittedly two very different versions of this event presented by the evidence, and continues by assuming the truth of Maya's recollection of this event. Defendant then shifts to a tactic minimizing the trauma inflicted on Maya because the event lasted a short period of time. Defendant perhaps fails to appreciate that rape typically takes place in a matter of minutes. The duration, oh, wow. They just went right there. The duration of an event bears no relation to the trauma inflicted, and defendant offered no psychologist or psychiatrist to testify to this absurd position. Defendant then suggests that Maya was not really upset during the false imprisonment and battery by Miss Beatty and others, except the defendant fails to account for Miss Beatty's admission that Maya did not want the photographs taken. Maya objected that Maya was upset, and nonetheless, Miss Beatty unfortunately proceeded with the photos. Defendant next suggests that Maya's version of events, that no photos and no disrobing took place on her return for the dependency court hearing, is not credible. Again, defendant cannot demonstrate that the jury's belief in Maya's testimony was against the manifest weight of the evidence. Defendant failed to include the photographs in Maya's medical record, and the photographs contain no date and timestamps or metadata to firmly establish the time the various photographs were taken. Defendant revealed the identity of Nurse Alside, one of the nurses who assisted Miss Beatty in taking the photographs, only months before trial and 5 years into litigation. Miss Alside's testimony was so ambiguous, to say the least, as she could only recall one photo session and could not recall what clothes Maya was wearing to distinguish the before or after photographs. Maya's testimony was the clearest and most consistent version of the events, and the jury was justified in taking Maya's testimony at face value given the absence of clearly contravening testimony or defense from defendant. Unlisted Law says, stream is up for noon Central tomorrow. Now, sleep. Okay. Kurt, good luck with this one. It's got a lot in it. Thank you very much, sir. Now you tell me I'm reading too fast? Who's... Summarize every so often. Okay. The plaintiffs don't agree with the defense. Should I be more verbose?
Good summary.
Okay. So this one, they're basically saying that with the photographs, there's the defense version of the photographs don't account for why she's got different clothing on. They don't account for the timestamps or they don't have timestamps, so they don't account for when it occurred. They say it only happened one time, but it doesn't make sense if they're documenting pictures on her body to see if there's anything else. There would have been 2 times that they would have to see her body to photograph it. And basically they're saying the nurse they provided is just she couldn't recall anything. She was useless in that. Defendant concludes its argument with this throwaway line. Throwaway line. Here's the garbage the defendant finished this with. The photographs were taken to document her skin condition at the beginning of the day and at the end of the day. The jury would have rightly wondered, then why were the photographs not included in Maya's medical record, and why were there no skin assessments documented the hospital's findings? Defendant's throwaway line is a last-ditch attempt to justify the hospital's conduct through the argument rather than testimony and evidence. Motion for a new trial due to verdict against the manifest weight of evidence and due to the excessive compensatory damages and remittitor. For this other motions. That was too fast, sorry.
Just summarize. We're tired.
Mrs. R.A. is tired. Page 60, I start translating for you, says Becca. Does this... I love this stuff. I love reading these. This is great. The defendant admits that it did not obtain parental consent for imprisonment, stripping, and photographing of Maya. It argues this court erred in finding the release mentioning photography signed in October for medical purposes did not exonerate defendant from his actions 3 months later. It's saying we were covered by that initial form you signed when you came into the hospital. That covers this. 3 months later. As noted above, defendant waived this point by not asking for or obtaining a ruling. As the court observed, the proof these pictures were not taken for medical purposes is the failure to place them in the medical record. They were taken to try to bolster defendant's risk management objectives, and further, nothing in the release gave defendant permission to remove Maya's clothing. Defendant was free to argue this point before the jury, but elected not to. The defendant argued...
They're being a little feisty here. Like, you wouldn't say that remove their clothing She wouldn't say that so much in the court case because that could be maybe a little offensive, and you're not sure how that will affect the jury.
Yeah, they get a little more latitude to speak here when they're making a motion. But the defendant argues that there was expert evidence that all the events of the fall caused Maya to have PTSD. It says there's no evidence this event was a substantial contributing cause and there was no aggravation instruction. This continues to miss the point that the jury was entitled to find the defendant's conduct over 3 months through the false imprisonments, batteries, and intentional infliction of emotional distress substantially contributed to Maya's conditions, including this one. Defendant's torts collectively produced Maya's damages, and the jury was entitled to allocate those damages among the different claims. Laura, thank you very much. I appreciate the kind words. Dr. Brewerton testified that the perception of an experience, here Maya's treatment, or more accurately mistreatment at JHACH, as compared to her previous experience with Drs. Kirkpatrick, Cantu, and Hanna, is formative in the onset of PTSD. Dr. Brewerton testified that the 3 E's, event, experience, and effects, determine the child's likelihood of developing PTSD. Brewerton, that's the testimony, okay. Given the negative combination of the 3 E's at JHACH, as compared to her previous experiences with her mother, father, and brother supporting her through difficult and challenging treatments, gave rise to Maya's PTSD. Defendant's alternative to the jury's award, a suggestion that the maximum lawful range for Maya's non-economic damages would be no more than $150,000, is nothing more than a shot in the dark. Defendant offered no expert testimony to support this limitation, and defendant's suggestion is an invitation to the court to supplant the jury's assessment without any basis other than the defense counsel's post-verdict unsupported argument. So this whole thing is basically saying she has PTSD because of what they did to her, and they nailed all the 3 factors that cause PTSD. And the fact that they come in there and say, if there is something, it would be worth maybe $150,000. There's no calculation with that. It's basically it's a useless number. Another renewed motion for directed verdict for a new trial or verdict against the manifest weight of the evidence on punitive damages, amount, and remittiture. Man, guys, I thought I could do all 88 pages, but now the words are getting a little blurry. Let's see what we can do. Plaintiff adopts the arguments on the defendant's liability for punitive damages, the jury's discretion in awarding those damages, and that the award did not violate Florida law. As noted above, the punitive award did not exceed the statutory cap, the 3 times compensatory damages. So the defendant's complaints about the intent finding are irrelevant. The total amount of compensatory damages awarded for the January 6 false imprisonment and battery were just over $27 million. The punitive damages awarded on this combined claim were $25 million, less than the amount awarded for compensatory damages. Now we're on to the battery. January 6th, motion for new trial on excessive compensatory damages. Defendant's argument that the batteries did not involve striking with a fist or weapon again shows defendant still does not get it. Under defendant's position, a sexual battery would not justify a large compensatory award. Defendant ignores that the harm here was not simply the unwanted contacts, but that Maya has to endure them from a woman she found intolerable, who at the same time was telling Maya things like she would be her mother now and that Beata was in a mental institution. The harm was exacerbated when Maya was deprived of her mother's touch forever. It also ignores Maya's testimony on how painful the CPRS made those touches by staff trying to show she did not have CRPS. Plaintiff adopts the responses above on the compensatory damages, including defendant's failure to suggest a meaningful alternative, etc. I love that they're just saying, same as above, plus this. It makes reading a little bit easier. What am I doing up so late? I didn't get the notice. We're reading a new document that just dropped, and it's a little spicy. It's fun. Renewed motion for directed verdict on the alternative motion for a new trial, or in the alternative, a motion for a new trial on a verdict against the manifest weight of the evidence concerning punitive damages and remittiture. What that means, this motion, is that we want the judge to say, change the ruling, in spite of what the verdict does, or in the alternative, if you won't do that, give us a new trial on this. And if you can't do that, just reduce the number we have to pay. They're asking, just make it better, judge. Make it better or do a redo. All right. Defendant asks, where is the clear and convincing evidence of actual knowledge of wrongfulness and high probability the injury or damage would result, then that the defendant intentionally pursued the course of conduct. The jury is entitled to conclude the acts they heard about that trial. Some are recited above and include battery, false imprisonment, and the myriad hateful things defendant's staff did to a 10-year-old girl were done with knowledge they were wrong at the defendant's direction. Remarkably, in this case, the jury observed one of those rare "a few good men" moments when the tortfeasor confesses on the stand. Betty admitted that she took the photos over Maya's objections and tears, and that despite the 10-year-old child's efforts to resist, unfortunately we did take the photographs at the direction of risk management. Kathy Beatty. I've called her Betty this entire time. Her name is Beatty, Kathy Beatty. Beatty exhibited appalling conscious disregard for Maya's rights. The jury was entitled to draw the inference from defendant's relentless actions. Plaintiff adopts the prior arguments on the punitive damages and the remittiture. Battery for hugs and other touches, renewed motion for a directed verdict, new trial, remittiture. Defendant's contention that Beatty's unwanted touching and kissing should not have been offensive to Maya is a classic jury issue. As noted above, when viewed in the context of Beatty's statements on now being Maya's mother, etc., and that Beatty was Maya's primary tormentor within the hospital, the jury found that Beatty's unwanted advances were incredibly damaging to Maya's future mental health. Defendant did not present a psychiatrist or a psychologist to suggest otherwise. Plaintiff adopts the prior responses on allocating damages among the claims and the jury's discretion in settling damages.
So that's interesting because they said that they couldn't go see a psychiatrist on their own because it would have opened all of those, they would have brought that into the trial. So there couldn't be a psychiatrist that said she was okay because they kind of shut that tap down to them.
Intentional infliction of emotional distress, renewed directed verdict, new trial, remittiture. Much of defendant's argument is reciting its spin on what happened and contending the jury should at least have not viewed things as it did as that bad. Many of the facts plaintiff discusses are relevant here, along with many other actions defendant took to try to break Maya and her family from their position Maya had CRPS. This included cruel comments, taunting, deprivation of family gifts, and religious and other items. Defendant again claims it was badly prejudiced by the negligent training evidence. As shown above, defendant ultimately acknowledged negligent training was relevant to the issues in the case. It has not pointed to where it asked for limited instruction after the directed verdict. As also shown above, Florida law makes defendant liable for shortcomings by its staff and personnel, which may result from a lack of supervision, training, etc., or from direct orders such as those from risk management. Defendant cites only one case in this section, Metropolitan Life Insurance Company versus McCarson, for the proposition that intentional bounds infliction of emotional distress claims must demonstrate conduct that is beyond all possible bounds of decency, atrocious, utterly intolerable in a civilized community, and must be committed with the intent to cause severe emotional distress or with reckless disregard of the high probability of cause that severe stress. That was a tough one. Sorry if I stumbled on that. The jury was instructed, and the plaintiff more than met this standard, but McCarson does not help defendant because it involved a very different situation from that here. Mama of 3, thank you for gifting 5 memberships. Thank you for a generous donation. In McCarson, the Supreme Court recognized intentional infliction of emotional distress as a cause of action in Florida. However, the court found the insurance company against whom that claim was made did nothing more than insist on its legal rights, the insured performance of contract requirements, in a permissible way, even though it knew its actions were certain to cause emotional distress. Here, defendant had no legal right to falsely imprison or batter Maya, nor did defendant have the right to mentally abuse Maya and her mother in its relentless effort to vindicate its indefensible actions. Defendant also knew its actions were certain to cause emotional distress because that was the point, to cause Maya and Beata such emotional distress that they would confess to having fabricated Maya's illness simply to stop the torment. Plaintiff adopts the prior responses on allocating damages among the claims, the jury's discretion in settling damages, etc. Medical negligence, renewed motion for directed verdict on the breach of duty, causation, and for manifest weight. Defendant's arguments seek to revisit a classic jury questions on the evidence and competing expert opinions. The jury heard how defendant suddenly changed its CRPS diagnosis, leading to failures to properly treat Maya's condition and causing Maya pain while in the hospital, as well as long-term consequences. Defendant tries to limit the question of its negligence to administering ketamine. However, defendant's malpractice was not so narrow. Rather, as demonstrated by the evidence and expert testimony, defendant's malpractice malpractice was comprehensive, the failure sweeping, and the apathy palpable. Dr. Chopra testified that JHACH absolutely breached its standard of care by interrupting Maya's CRPS treatment, subjecting her to physical therapy with deleterious effects, repeatedly aggravating Maya's pain response, and all the while questioning her pain and disparaging her. If you repeatedly aggravate the pain, which physically or mentally, if you aggravate the pain, the brain changes. Here you have a 10-year-old girl who has this horrible, excruciating, body-wide burning pain. She's got the skin lesions, and which is a big deal for a 10-year-old girl. And you're also isolated from your loved ones. And you have people coming in, seeing you every day, all day long, people who are not friendly. Dr. Chopra continued, these people are not very friendly, they're not there to help her. They're not trying to help her. They're trying to actually question that she does really have pain. And they're touching her again and again and again. They're putting her into physical therapy, which she's trying. And it's not like she did not try. She did try physical therapy. She did what they said, and she was not improving at all. And this, I think, really is what aggravated her condition. These actions are the distilled essence of medical malpractice. Dr. Neuberger testified that Dr. Sally Smith and the members of the team, including Major's medical approach, diverged from the accepted standard of care for hospital treating physicians to conduct a systemic and rigorous differential diagnosis, in which all the alternatives were seriously considered and honestly represented. In his second deposition, which was read to the jury, Dr. Neuberger responded to defense counsel's questions about whether his opinions had changed since his first deposition based on Dr. Neuberger's review of additional information on medical records. With regard to the impact on this family and Dr. Smith and other Johns Hopkins All Children's Hospital workers, they have been more deeply informed with regard to the trauma suffered by the girl and her father with regard to their impact in propelling the mother's taking her own life, with regard to following impacts on the child of the trauma, which have produced an acute and concerning medical set of consequences that derive directly, in my opinion, from the malfeasance of the staff of the hospital. When asked further about the standard of care opinions, Dr. Neuberger opined that he had even more. I think there are about 5 as they pertain to the so-called multidisciplinary team which Smith organized and led, and how this team came to be used as the voice of Smith, adding weight, gravity, and breadth to her opinions affecting people within and outside the hospital, including a prosecutor who had no business being a member of a hospital team, and including the person in the Child Protection Agency who herself took a prosecutorial, there it is, and punitive role. So this also, to me, was a hospital violation of the standard care, and it enabled, for example, Major and D's to point to a team that was opining. And then another opinion is that the team, to the extent that you're able to discern their thinking, was an exercise in groupthink, where there was very little curiosity about alternative explanations for what was being before them, but rather the pilot of the plane was clearly Sally Smith, and all of its actions were in conformity with, as I read this, the opinions, the skewed representation of history, in her opinion, the one that was stapled to the paper record. For all of its hand-wringing over Dr. Neuberger's testimony, the defendant did not rebut Dr. Neuberger's assertion that the defendant exhibited an absence of curiosity for alternative explanations beyond the hospital's overarching theory that Maya was performing a charade and faking her pain. The jury was presented with an admitted fact. When Dr. James Lewis, the neuropsychologist enlisted by Dr. Sally Smith, completed his report and directed that JHACH involve a pediatric neurologist to definitely rule in or rule out CRPS, JHACH never took that step. That is, JHACH never consulted with a pediatric neurologist to take the diagnostic step DCFS neuropsychologist directed, despite having Maya in the hospital for another 3 months after Dr. Lewis's report was published. The jury was rightfully infuriated to have the defendant's admission that for all the effort defendant expended in attempting to cloak the hospital as an institution simply following the lead of DCF, when appropriate diagnostic steps would have disapproved the defendant's charade theory, it simply chose not to consult a pediatric neurologist. The defendant never called a pediatric neurologist to testify, and this admitted fact, per se malpractice, went unchallenged and unexplained over the course of the 9-week trial. We're almost there. What's that? I don't know. My brain's fuzzy. I'm following this. I'm not sure if it's making sense to everybody else. Greener says, someone didn't tell me Ari was going live. Well, someone emailed these to me, Greeners. Who would that be? We got a couple copies sent to me. Thank you for everybody who sent these. This is a directed verdict or in the alternative motion for a new trial for legal errors that deprived the defendant of a fair trial concerning liability for Dr. Sally Smith. The jury evidence from which it was entitled to find Dr. Sally Smith was defendant's apparent agent. The jury heard evidence from which it was entitled to find Dr. Sally Smith was defendant's apparent agent. But this is an academic point, given the jury also found other doctors of defendant committed malpractice. So the malpractice verdict will stand regardless of Dr. Smith's status. The claim Beata knew Dr. Smith was a member of the CPT does not preclude Dr. Smith from being the defendant's agent. Likewise, a police officer being hired as a private security, even if it did, the defense focuses only on Beata's alleged knowledge as of October 11th, without citing any record evidence. Defendant ignores that the hospital led Jack and Maya to believe that Dr. Smith was a hospital physician, acting on behalf of the hospital when she entered Maya's room wearing a Johns Hopkins All Children's Hospital security badge and lab coat embroidered with JHACH's colorful logo. Defendant cannot impugn Beata's alleged knowledge to Jack and Maya when Dr. Smith entered Maya's room as Jack was assisting in cleaning up his daughter after defendant administered medications for a bowel cleanout, since Beata was not there. Jack and Maya both testified clearly that they were given the impression by the nurses who escorted Dr. Smith in and out of the room that she was an agent of the hospital. Moreover, Dr. Smith admitted to wearing a JHACH security badge during this brief meeting with Jack and so-called evaluation of Maya. And although Dr. Smith denied wearing a white doctor's coat and claimed she never wore a white doctor's coat, that testimony was not credible and was rebutted by the separate victim of JHACH's and Dr. Smith's who testified in plaintiff's rebuttal case, Alina Kushner. Defendant attempts to minimize the impression given to Jack and Maya by Dr. Smith arriving in Maya's hospital room wearing a JHACH lab coat by arguing her doing so was not an act of the hospital, but rather her own conduct. Obtaining a JHACH lab coat is no easy task, and the natural question to the defendant's argument is how many other doctors the defendant allowed to roam in his hallways in stolen lab coats. Regardless, defendant presented no testimony to suggest that Dr. Smith absconded with a lab coat or security footage from hallway cameras to suggest she snuck into Maya's room like Jason Bourne without the hospital's knowledge. I love the movie reference, Jason Bourne. That's a good action flick right there. Defendant also argues that even if Dr. Smith was presented to the Kowalskis in the manner that Jack and Maya testified, she was not in a position to perform treatment. Defendant asks a rhetorical question that is easily answered by looking at the evidence before the jury during its deliberations. But what is the evidence that Dr. Sally Smith provided treatment without regard to whether it was negligent or not? In failing to answer its own question, defendant ignores its own medical records demonstrating that Dr. Smith was heavily involved in Maya's care, as well as Dr. Smith's unjustified access of Maya's JHACH medical record before the state had even opened a case via the Second Florida Abuse Hotline report. Just for bonus points, can you guys recall all the movie references that have been dropped or included in this motion? Let's see which ones you guys can recall. Defendant also ignores Dr. Smith's text messages in which she directed that Maya may be removed from all her medications, and that Dr. Paola D's testimony that shortly after Dr. Smith's text message, all Maya's medications were ceased. On cross-examination, the jury heard that Dr. Smith had directed allergy tests to be performed, consulted with several other JHACH physicians about removing Maya's report without Jack or Beata's consent, recommended repeating lab tests, recommended checking Maya's immunoglobulin Immunoglobulin. It sounds like a Halloween character. IG status. IG profile and IgE directed Dr. D's to get Maya off as many meds as possible. The suggestion that the case against Dr. Smith was supported only by the testimony of Dr. Newberger is belied by everything recited above, all of which was before the jury. The case against Dr. Smith was also supported by JHACH access logs showing her illicit access on October 8th, the testimony referencing Dr. Smith as JHACH's child abuse physician, and Dr. Smith's text messages saying staying in constant contact with the treating hospitalist and weighing in on treatment decisions, and JHACH's 3,000-plus page medical record in which Dr. Smith's name was ever present. Defendant closes its argument again by insulting the jury, stating that Dr. Smith's diagnosis was made in her role as a medical director of the child protection team and that simply was a concept too difficult for the jury to accept or understand. Defendant fails to cite record evidence for Dr. Smith's alleged diagnosis. Greener says, can you cover the Sarah Boone motion for a private investigator at 11:30? Greeners, is this a new one?
No, Scott, I already told him no.
Is this a new one, Greeners? We are going to be done with this about 11:30. I'm just saying. Negligent training again. Motion number 108. Plaintiff adopts its response above. Defendant acknowledged negligent training was relevant and has not cited where it was asked for limited instruction. Defendant errs by suggesting count 14C could only go forward for an employee who is outside his or her scope of employment. That statement is overly broad, therefore inaccurate. As explained above, Section 766 mandates that hospital ensure the competence of their medical staff. Section 766 imposes a duty on the hospital to supervise the medical staff and hospital personnel. Throughout the trial, plaintiff sought a stipulation to fold the medical negligent training allegations into the medical malpractice claim, because defendant, at times it appeared the court, felt that the claims were redundant. Defendant refused to accept plaintiff's offer to stipulate to such an accommodation, even though the plaintiff had pled count 14C in that fashion. Defendant complains that its lies about the risk management failures, accreditation issues, and immediate jeopardy finding came back to bite it. Plaintiff adopts its argument above on accreditation. Furthermore, even absent a negligent training claim, Dr. Corcoran's testimony was expressly permitted by Section 766, Florida statutes, as a part of the medical malpractice claim, which provides, notwithstanding Section 5, in a medical negligence action against a hospital, a healthcare facility, or a medical facility, a person may give expert testimony on the appropriate standard of care as to the administrative or other non-clinical issues if that person has substantial knowledge by virtue of his or her training and experience concerning the standard of care among hospitals, healthcare facilities, or medical facilities of the same type as the hospital, healthcare facility, or medical facility whose acts or omissions are the subject of the testimony which are located in the same or similar communities at the time the alleged act giving rise to the cause of action. This is one of the most protective med-mal laws I've ever heard. Basically, you have to be an insider with identical experience in order to provide testimony against a hospital. This says you have to be in a similar size hospital, in a similar area, in a similar location, having with similar medical facilities, the same type of hospital. The acts and admissions have to be. It's basically, it says you've got to have basically experienced this yourself for this to count. Yeah, Dr. Corcoran did a great job, by the way. Defendant then incorrectly asserts that Dr. Corcoran testified without actual evidence that the hospital's governance and oversight failures spanned the time during which Maya was admitted at the end of 2016 and into 2017. Defendant's corporate representative and vice president for quality and safety for the Johns Hopkins Health System, Angela Green, testified in her November 3rd, 2023 deposition after the court learned the defendant had elicited false testimony without providing its expert with relevant and material documents, that the issues noted in the January 2019 CMS survey finding the hospital was in immediate jeopardy dated back at least 3 years, and in some cases 5. The town hall meetings admitted into evidence produced further basis for Dr. Corcoran's testimony, as in those meetings the hospital's interim CEO admitted that he had verified and validated the stories of retribution and retaliation that Dr. Corcoran discussed had occurred as far back as 2015. Motion for new trial based on legal errors in the admissibility of evidence from witnesses. Defendant makes no specific claims in this section. Only they're like, there's nothing in here. It's put the title in there and then it doesn't say, there's no stuff underneath it. Only referencing many legal errors involving the inadmissibility of testimony from witnesses and documentary evidence. Defendant argues these errors entitle the defendant to a new trial on the claim for medical negligence. The plaintiff is unable to respond to such generalized and overly broad arguments and relies on the point-by-point responses infra. So yeah, they basically they put a placeholder there, and they never wrote that paragraph. They're like, we want a new trial because of the mistakes that were made, and then they forgot to list the mistakes. Motion for a new trial on excessive compensatory damages. The defendant argues that the jury's award of $22 million in non-economic damages to Maya for medical malpractice claim duplicates the $16 million non-economic damages for the jury awarded for the false imprisonment and the battery claims. Again, the jury is entitled to apportion the damages over multiple causes and instructed not to duplicate damages. The defendant offers no basis and is unable to demonstrate that these non-economic damages were duplicative. Defendant's real complaint is that they failed to put on any testimony or evidence to apportion the damages and provide the jury with a basis to allocate Maya's future damages to her pre-existing condition. But this is a self-inflicted wound. Having found defendant liable for medical malpractice, the jury could decide that JHACH was responsible for all future consequences to Maya. The jury was instructed to award future damages and damages for aggravation if it could not apportion the damages. Defendant is usually liable for all injuries caused by his misconduct. Defendant then attacks the experience of Dr. Pradeep Chopra, one of the plaintiff's CRPS experts, and in a bizarre admission, defendant laments that it did not file a Dobert motion, making the challenge now in a belated attempt to use it as a basis for a new trial. Defendant's arguments include the assertion that Dr. Chopra had not treated even one other patient, a clear misstatement of fact and testimony at trial. Defendant's argument appears to accept that CRPS is a lifelong condition that waxes and wanes, although defendant's various physicians testified, counterproductively, that Maya did not have CRPS, and she had CRPS, and then she did not, that CRPS was curable, or it was incurable. Defendant perhaps regrets its inconsistent positions at trial. Not a single JHACH witness ever conclusively took a position that defendant did or did not believe that Maya had CRPS, but Dr. Chopra is not the proper target of that regret. Defendant then attacks the economic damage award based on the prior $4.5 or almost $5 million for Maya's loss of earning capacity for defendant's medical malpractice. But this $3 million award under the IIED was for both loss of earnings and future medical expenses. And again, the jury was entitled to allocate damages among the claims. The jury can split up the money. Okay, they can do this without having it double up. They're saying because it was so much money, clearly they copied. Let's see. The jury's award on this point was less than the upper limit suggested by plaintiff's vocational rehabilitation expert, Robert Tremp, and its economist, Christy Kirby. We liked her. A defendant cannot challenge the jury's award in response to question 47 on the verdict form as excessive and would be invading the province of the jury, given that the economic damages under the IIED include both loss of earnings and future medical expenses attributable to that conduct. Defendant consented to the combined damages question and cannot now challenge the result. Importantly, the jury is not bound by the defendant or the plaintiff's suggestions and has the right to accept or reject all or part of the expert's testimony. Since the defendant offered no methodology to determine Maya's future medical care, the jury was left with Dr. Bifulco's unrebutted testimony that Maya would need 24-hour medical care for certain 10-year spans during her life, likely to be in the middle or later part of her life. The jury's valuation of Maya's future medical care was well within the limits suggested by Dr. Bifulco in reliance on the informed opinions of Drs. Kirkpatrick and Brewerton. Motion for remitter on excessive compensatory damages. They list this for every single motion, like all the charges, so some of it repeats. Plaintiff adopts the prior responses on allocating damages among the claims, the non-duplication instruction, the jury's discretion in setting damages, etc. Defendant submits that the maximum lawful range for the future economic damages from the alleged medical negligence would be less than $100,000. That's how much the JHACH was willing to concede. Less than $100,000 is what it's worth here. Based on what? Defendant offered no evidence or testimony to support its post-trial conjecture. Defendant asserts the medical treatment during the hospitalization actually caused little or no physical injury to Maya Kowalski in the hospital. Which one is it? Physical injury or no? That treatment provided a continuation of the program of therapies commenced at Tampa General Hospital. Commenced at TJH in the summer of 2015, defendant still fails to appreciate that Maya's brief admissions at Lurie Children's Hospital in Chicago and TJH in the summer of 15 have nothing to do with the harm it inflicted on Maya in late 2016 and early 2017. Defendant still refuses to acknowledge the overwhelming weight of the evidence that its treatment was both cruel and apathetic, with Maya receiving less than 5 hours of cognitive behavioral therapy over the course of her 3-month admission, even though multiple JHACH doctors and defendant's CRPS expert testified that CBT was one of the primary pillars for Maya's presentation. JHACH medical negligence is highlighted by the treatment Maya received at TGH over the year earlier, where Dr. Jennifer McCain confirmed Maya received CBT multiple times per week, with each session lasting approximately 1 hour. Had JHACH actually continued the program of therapies commenced at TGH, Maya would have received consistent CBT at a frequency on par with that of TGH. This never happened. Law and Lumber, Rob is here. He just gifted 10 memberships. Thank you very much, Rob. Good to have you here. We're tearing through this document. I'm hoping I'm still making sense. My mouth is going. I'm not sure my brain's connected to it anymore. Robert McNamara, welcome to the gallery. Good to have you here as well. Let's see. It's getting better. Lastly, defendant argues without support that Maya's future non-economic damages should not exceed $500,000. Defendant presented no, zero, zilch, none evidence to support this assertion that $500,000 is the appropriate measure of Maya's non-economic damages. Defendant just pulls a number out of its hat. Sorry, oh my goodness. Guys, it's late. It's late. I just about went somewhere where it clearly did not say. My apologies. Issues affecting the claim of billing fraud presented by Mr. Kowalski individually. Defendant's insistence that no paper bill was introduced is both factually incorrect and ignores Jack Kowalski's testimony that he paid toward the outstanding balance and paid increased premiums following Maya's discharge. Although bills were submitted, plaintiff understood defendant had agreed that evidence on medical liens would be introduced after the verdict and consequently suggested the jury award nominal damages. While the amount by which the liens may exceed the non-CRPS charges because of a defendant's fraudulent billing may be substantial by comparison to the liens, plaintiff does not want to incur delay litigating that issue. Consequently, plaintiff reiterates his willingness to reduce this award to a nominal amount. There are statements in the defense argument plaintiff could challenge, but will not take the court's time to do so. They're like, we're not going to argue this one. As to the defendant's rant on the plaintiff's practical suggestion to expedite this question, defendant cites no law that a plaintiff cannot suggest a remittitor. Section 768 provides for the court to review the amount of such an award to determine if the amount is excessive or inadequate in light of the facts and circumstances that were presented to the trier of fact, and does not specify who must make the request. The Supreme Court holds that the trial court has discretion to deny the defendant's motion of her new trial if the plaintiff will accept a remittitor that reduces the award by subtraction to the maximum recovery supported by the evidence. Again, while the plaintiff expects a hearing on the liens would establish a damage figure in the excess of $1, plaintiff does not want to further delay in the entry of the final judgment. Here, what we have here is in this one section, the issues affecting the claim of billing fraud presented by Mr. Kowalski individually. I think the plaintiff is waving the white flag in this one section. They're saying reduce this. It's fine. We're not going to fight this. We either don't have the evidence to do this, or the delay this is going to cause to fight this is not worth it to us. It's $5 million. It's $5 million, and they're saying we're not going to argue this one. And I think that means that they probably have, the jury probably over-awarded in that area. That's my take on it. Issues affecting the claims represented by the estate of Beata Kowalski. Intentional infliction of emotional distress, seeking survival damages, renewed directed verdict motion, and new trial motion. Rob says, 89-page pleading, you streamed all day. Consider this a reminder that you also need to sleep. I know, hypocrisy from me, but you're too valuable to lose that buttery voice. Take care of yourself. We are almost done, Rob. We're almost done. We're going to make it here. We've got just a little bit left. The plaintiff will elect the wrongful death claim, but responds to defendant's legal arguments, which it adopts for the wrongful death claim. Defendant's factual spin ignores the concerted action harming Beata. Immediate retaliation against Beata for challenging defendant's doctors and urging them to discharge her daughter, refusal of the family's request for discharge, and false imprisonment of her daughter for having challenged defendant's doctors, another woman, defendant's social worker, kissing and touching her daughter while telling Maya she would be her mother and that Beata was mentally ill and been placed in a mental institution, that same social worker suggesting divorce to Beata's husband, interrupting phone calls between mother and daughter, and isolating Maya, denying her cards and gifts from her mother, etc. Defendant then poses another rhetorical question. What evidence is there that some employee committed an extreme and outrageous act beyond all possible bounds of human decency, atrocious conduct utterly intolerable in a civilized community, and did so with the intent to cause Beata severe emotional distress or with reckless disregard to the high probability of causing that stress? The answer is easy. Defendant's doctors exchanged text messages in which they predicted Beata's suicide, having had another mother do the same thing. Dr. Laura Vos, who testified by deposition at trial and bizarrely served on JHACH's Ethics Committee in 2016 and as co-chair on JHACH's Ethics Committee in 2017, texted Dr. Tepa Sanchez shortly after Beata's suicide to relate that in the lead up to Beata's ultimate demise, she had predicted Beata would take that final step. Whether this is evidence intent to cause Beata severe emotional distress or reckless disregard to the high probability of causing Beata's suicide is a question the jury did not have to answer. Either way, defendant's ethics committee and actual knowledge of Beata's severe emotional distress and had actual knowledge of Beata's severe emotional distress and failed to intervene. Defendant lashes out at plaintiff for having resorted to a great conspiracy theory and a plan akin to a Mission Impossible episode. Okay, there's your movie count. How many were we up to? Defendant then weaves a theory that plaintiff did not argue and ignores that court granted defendant's motion for summary judgment on plaintiff's count for civil conspiracy relatively early in the case. As explained above, the court ruled in defendant's favor when it renewed its objection to Dr. Newberger's mention of a conspiracy and excised that testimony. Defendant waived any other argument that this lone utterance of the word conspirator elsewhere in Dr. Newberger's testimony justifies a new trial, since defendant did not renew its objection to that word/testimony and did not ask for a curative instruction after Dr. Newberger's testimony was read. Further, one utterance of the word conspirator in the context of a 9-week trial is harmless error, if error at all. Plaintiff argued before trial that Beatty was the hospital's hitman, but that term and other similar terms were excluded when the court granted defendant's motion in limine. Lunch is soon. In short, defendant's elaborate doctor's revenge novella is not a rehashing of evidence presented to the jury, but rather defendant's attempt to paint the jurors as conspiracy theorists. Although there was evidence from which one could infer that doctor's revenge conspiracy existed, plaintiff did not argue that theory. Rather, plaintiff focused on the jury on multiple, atrocious, intolerable, extreme, outrageous acts. The actors included Miss Beatty, Dr. Vos, Dr. Sally Smith, Dr. Dees, Dr. Tepa Sanchez, Dr. Dolan, and last but not least, JHACH's Risk Management Department and its senior counsel, Jackie Crane. There were likely others involved, although the notable absence of any testimony from a risk manager or Miss Crane leads to the natural question: if defendant's strawman doctor's revenge conspiracy theory orchestrated by risk management was so easily disproven, why did defendant not call anyone from the risk management department to testify, especially considering the prominence of the damning risk management notes throughout the trial? The standard instructions given by the court do not require that Beata heard or witnessed the cruelty in person, and the court has rejected adding that gloss to the law. Defendants' actors had to expect Beata would hear of their taunts of Beata losing her child, her husband, and her freedom being committed, and the harms they inflicted on her 10-year-old daughter. Defendant not only attacks the plaintiff for a conspiracy theory defendant alone has articulated, defendant then attacks this court, as it did in open court, for not performing its gatekeeping function. For defendant desired list of actions, it need only look at the highlights of its actions above: the Eighth Amendment complaint, the order granting leave to assert punitive damages, and the response to defendant's motions for summary judgment. A simple list, however, does not capture the relentless frequency of this conduct. The death by 1,000 cuts. The jury was entitled to infer defendant orchestrated the conduct, perhaps to deal with a mother who offended or challenged the wrong people, those being unqualified doctors wearing JHACH lab coats. Wow. Robert, welcome to the gallery. I think I got you already, but welcome again. The court exercised its gatekeeping function throughout the trial by excluding Beatty's correspondence documenting that she and the hospital were pushing for further restrictions on Beata's visitation rights without justification, Beatty's arrest record for physical violence on a child similar to Maya's age, and excluding the presence of that arrest record and Beatty's personal record reflecting and proving without a question that defendant knew of Beatty's violent history. Defense counsel's cease and desist letter to Mark Zimmerman to avoid the jury learning that the defendant drove the dependency proceeding, and the sexual assault of Maya documented in defendant's medical records, and the failure to report that sexual assault to the Florida Abuse Hotline, which was other outrageous conduct the jury could have considered. The jury was instructed on substantial cause and defendant's unsupported statement. The jurors could not sort out the causes as just that, unsupported. Defendant's professed inability to see the disdain and hatred the ketamine girl text evinces reaffirms that the defendant just does not get it. Plaintiff will indeed elect the wrongful death claim over the survivor claim, so nothing more needs to be said about survivor damages. Intentional afflictions of emotional distress causing death by suicide.
That's interesting. They dropped the one but kept the other.
Plaintiff adopts the responses above. Defendant continues to recast the facts in a manner the jury loudly rejected. Leading up to Beata's suicide, defendant continued to inflict psychological and emotional blows on Beata. In the 30 days leading to Beata's suicide, a time frame defendant focuses on, the defendant, 1, ignored Beata's request to have Beatty removed from Maya's care, then allowed Beatty to molest Maya in the chapel, refused to allow court-ordered visitations by phone and FaceTime, isolating not just Maya, but inflicting further severe emotional distress on Beata, refused to facilitate family therapy sessions ordered by the dependency court, ignored Beata's medical decision-making rights that had been preserved for the dependency court, and tormented Beata further by threatening to remove Maya's port, did not allow even a single FaceTime call between Maya and Beata in the last 10 days of Beata's life, despite the dependency court's December 27th order, and the hospital facilitate these FaceTime calls both at 11 a.m. and 5 p.m. each day, and then redirected Betty to threaten Maya that she would not be allowed to attend court to see her mother if she did not submit to stripping for Beatty and subjecting herself to semi-nude photographs. Beata was the target, and she knew it. JHACH testified to learning these actions directly from Maya, relaying that information to Beata. Question. Now, the jury may hear testimony from your daughter about Miss Beatty's physical contact with her. During these conversations, was Maya ever allowed to tell you about these? Answer. By notes. Question. And what was the effect on you and your wife about knowing what Miss Beatty was doing? Answer. It was just putting a bigger wedge in between everyone and more anger. Question. Well, was Beata becoming more desperate at this point? Answer. Yes. Question. And what was her concern? Answer. Number 1, Maya's health. Question. And were you reporting back to your wife about her health every time you visited? Answer. Yes. And yeah, it was difficult. Then continuing, question, and we're going to refer to some court video on this point in the moment, but I'm going back to the dresses. Who picked out the dress for Maya? Answer, Mom. Question, so what was the effect when she heard Maya couldn't even get the dress? Answer, it crushed her. Question, from everything you perceived about your wife, how upset was she when she found out that her daughter was being treated this way? Answer, it was extremely difficult for her. It was taking all the air out of her balloon. I mean, you could see that it was just eating at her. She lost a lot of weight during this time. Beata learned much of this directly, even when her visitations were routinely shut down by Beatty. Jennifer, thank you so much for 5 memberships. Appreciate your generosity. Rob, I was hiding behind this. The beard is gone. It was No Shave November, and I grew it out, but it started knocking food off the fork, and as soon as it gets between me and my food, it has to go. So that's how it went. But I was hiding. I wasn't think you're going to notice. Beata learned much. Oh, let's see. Instead of focusing on these horrific facts, defendant plays the same game it did at the trial, hiding its head in the sand, rather than attempt to explain how it was that Maya did not have any FaceTime calls with her mom in those last 10 days, despite the dependency court's December 27th order expressly requiring those calls. Defendant instead focuses on a couple photographs taken on or just before Christmas with Maya smiling and holding a present. The same approach failed at trial when defendant opted to ignore Beatty's horrific actions and instead played a video of Maya playing the piano in the hospital lobby with an unidentified physician and explaining, "This is Johns Hopkins." The jury rightfully rejected defendant's saccharine Saccharine. I've never said that word before in my life, just so you know. Saccharine version of events when plaintiff displayed defendant's horrific, outrageous acts with the correct motto, "This is the real Johns Hopkins." Defendant's public policy threat to this court is preposterous. If the court does not grant relief on this claim, no rational hospital administrator will be willing to keep a child in DCF custody for any period beyond the point where a child is eligible for medical foster care. Rather, Florida's public policy will be served by reinforcing with rational hospital administrators that hospitals cannot falsely imprison children without legal authority, should not covertly videotape children, should not entrust sheltered children to the care of violent social workers with criminal histories, should not direct the battery of children in their care, and if the administrators are aware that their actions are driving the mother towards suicide, they should address the hospital failings, not hide them. Renewed directed verdict and motion for a new trial based on verdict that is contrary to the manifest weight of the evidence. Just as the defendant has done, plaintiff adopts his previous responses to defendant's motion for directed verdict, responses to defendant's motions for summary judgment, responses to motions to dismiss, and motion to leave to assert punitive damages. The manifest weight of the evidence, as the jury appreciated, supports the finding of liability against the hospital for intentional infliction of emotional distress. We're so close. Motion for a new trial based on legal errors in the jury instructions and on the decision to add a second theory of causation to the trial midstream. Without citation to the record, defendant erroneously claims that plaintiff's closing argument equated uncontrollable impulse to the substantial factor test. Plaintiff argued, when you are looking to see whether you should check yes, that it was what Johns Hopkins did, whether they were a substantial factor or that she acted on an impulse, please consider how powerful the maternal instinct is. That was Mr. Anderson. The use of the term or is instructive and does not indicate interchangeability of these terms.
Indus 9001 just sent a super sticker with 0.99.
Thank you for the super sticker. I'm not sure why it's not coming up on my screen. Oh, there it is. Indy, thank you very much. Indy Cindy, appreciate you. That was Anderson. The use of this term or is instructive and does not indicate interchangeability of these terms, but their distinction. So the two terms, whether they were a substantial factor or that she had acted on an impulse, it's either or. The defendant's argument rehashes its criticism of the court for allowing the jury to consider two questions in what the defendant has always claimed is a novel legal area. The court adopted a reasoned, measured approach to avoid having a retrial, depending on the appellate court's view of the law. The jury, having answered the defendant is liable under either standard, has eliminated defendant's argument. It can complain that its desired theory was not embraced to the exclusion of the alternative, but the jury has rendered that complaint academic. Motion for a new trial based on errors related to the testimony of Dr. Richards. Defendant failed to call a psychiatrist to explain what led, in defendant's collective mind, to Beata's suicide. So defendant resorts to an attack on Dr. Scott Richards, whose expertise and opinions have been known to the defendant since Chapter 766 pre-suit process began. As defendant points out, Dr. Richards never met Beata due to her tragic suicide. On this point, Dr. Richards is no different than all defendant's experts who testified at trial. Dr. Elliot Crane, Dr. Randall Alexander, Dr. Sharon Levy, and Mark Anderson, none of whom ever met Maya, Kyle, Beata, or Jack. But each was more than willing to opine on the family's behavior and Maya's condition. Unlike Dr. Levy, Dr. Richards reviewed the entirety of the defendant's medical records and thousands of pages informing his forensic opinions. Contrary to the defense's unsubstantiated charges against him, he assumed nothing. Motion for a new trial. Look at this. We've got a conclusion. We're so close. Motion for a new trial on excessive compensatory damages remitted to her. Plaintiff adopts the prior responses on allocating damages among the claims, the jury's discretion in settling damages, etc. Basically, that's a big old ditto. Conclusion. Defendant argues the same positions the jury rejected, continuing to deny the horrific nature of its actions. Plaintiff Jack Kowalski, individually and on behalf of MK, a minor, and as a personal representative of the estate of Beata Kowalski, deceased, respectfully requests the court deny defendant John Hopkins All Children's Hospital motion, dated this 11th day of December. That is, that was long. So there we go. I've now read it to you. You can now close your eyes and go to sleep. It's nappy time. It's time to not nappy. That's diaper, right? It's nap time. Sorry, might be nappy time as well. I'm not. Give me a few years, I'll be there. It is. We made it to the end. If you go to the court on the 15th, I expect the pen to make an appearance. Couldn't think of a more appropriate use. Oh my goodness, we're looking at that very closely right now. It's not unreasonable to me to drive that far, but yeah, we'll see. The flights are a little bit. I think it's like $700 for a flight round trip, and then a hotel on top of that. I know we've got some people, Jules, for instance, who has offered to help pick me up from the airport and things like that. I'm worried about flying because the gear I have requires substantial battery sizes, which are legal to fly, but right at the limit. And I'm going to have multiple of them, and I can't afford them getting zoinked. But we're gonna check and see what happens here in the next little bit. All right. I think tomorrow we'll cover Sarah Boone's letter in the morning. Is that all right? There may be one more motion because the defense did file some more motions about juror number 1. So there might be one more response to that that will be turned in prior to the 15th. So it's gonna be good. Now I have to go back to the beginning. So watch it on 2 times speed and tell me if it's better like that. Let's see. Did the plaintiffs file anything about the jurors' S's? I haven't seen it yet, but I anticipate there might be a response. This is what I'll say. If I'm able to go to Florida for the 15th for the hearing, I probably will not be set up to live stream and commentate during the hearing. I could provide the feed, but I'm not sure if I could do a live commentary during that. Rob has an idea. What's that? I'm looking. Where's Rob's idea? Fun suggestion. I'll guest host your channel and let you call and be on your burner phone. That would be awesome. I love that idea. That is really cool. Rob, that sounds amazing. Let me see what we can do. All right, let's thank you, Angie Torres. Thank you for the gas money super chat. I appreciate that. You guys are too kind. Let us, before you send any contributing funds to this crazy cause, let us first do our homework on this end. So thank you very much. We'll let you know where we're at. Please fix the super chats. We cannot see them. Collie. I'm going to figure this out. I use a Chrome plugin to show my chats on the screen. Really, the whole screen. I mean, if you're able to see the whole screen that I'm looking at, this is what my chat screen looks like. I'll turn my face off so you can see that. So I have all sorts of quotes and things up here that pop up, and I can scroll up and down and click one, and it's a little weird because it shows up twice now. But it appears at the bottom of the screen, and my software takes this little piece and gets rid of the background and then makes it appear over my picture. Unfortunately, the text is also black, and I can't find a way to change the text color right now. So when I switch to say this camera here and overlay the image, sometimes it works really well, like when it's a black part of the image. But if I were to switch to my camera here, that worked well as well. It's a bad example. Oh, we have what? I have to leave at 5:30 in the morning? That's super early. Okay. All right. Sounds good. All right. I've got an early morning, which means we need to go to bed. If I can see through my blurry eyes to find the right music to play. It's almost appropriate that we play something quiet, like this, just to go to sleep. It's been a long day. Oh, yeah. All right. No, instead we're going to end on a high note, the way we started. Thank you, everybody. This has been a lot of fun. I appreciate all the comments. We're going to get to work on the Florida side. I'm really trying to make that happen. Rob, I honestly, I might hit you up on that if that's something that might work. We'll see if we can go there. All right. What little is left of tonight, I've got about 15 minutes of it here. When you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe until we go live tomorrow morning. It'll be, I think we've got an 8:30 start time. Court starts at 9 o'clock in the Hannah Payne trial. We do expect that we'll be in deliberation, probably before lunchtime, depending on how the breaks go and if tech support's needed. You guys, if you know, you know. So we'll see what happens tomorrow. Thank you all very much, guys. Thanks for your patience. We're gonna get through this trial and look ahead to the hearing that's happening later this week in the Maya trial, which will be hopefully amazing. Hopefully amazing. All right, that's everything I got. So I'm tired. I gave you all I've got. You guys have a good night. Be kind to each other. We'll see you tomorrow. Bye-bye.
I was kicked back, taking it easy.
Alex Stoller.
Scratch all that. Oh, that was terrible. I apologize.